So it's 10 a.m. So we'll go ahead and get started. I appreciate everyone coming in today. It's been a while. We got delayed for a little bit, but that's okay. We're back at it and got a number of stuff to get back to work. I appreciate the commission staff making through the craziness that we've had and over the course. So with that, I will call the meeting to order. The first order of business is we've got 2 amendments to the agenda that I'd like to propose. First, I'd like to, we have the Taipei Economic and Cultural Office who has kindly donated 30 in a second. Any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed? Hearing none, the motion carries. And so the first agenda item for section 3 here is the case number 2018-0097 in the matter of Minhei DBA Hente 4 Adams. And Secretary Mahdi, who will be addressing that on behalf of the commission.
That will be me, Mr. Chairman.
Okay. And is an attorney here on behalf of the respondent?
No, Mr. Matrani is an attorney based out of San Diego in Washington. He indicated because this was a consent order, he would not be appearing.
Okay. Well, please proceed.
Erwin. So, before we begin, this is a consent order involving an independent committee, or commonly known as a super PAC, which is went by the name of Hente 4 Abrams, which translated from Spanish literally means people for Abrams. It was funded by an organization known as Hente, based out of Phoenix, but the operation was known as Hente 4 Abrams. I'm going to get you a PowerPoint here in a second and outline some of the evidence that the investigation revealed. But this will be a consent order we're offering that they have signed. Hente 4 Abrams is admitting that they operated during the 2018 primary gubernatorial election as an unregistered, unregulated, essentially dark money super PAC, and is agreeing to pay a fine of an amount of $50,000.
Okay, and I think I might have the wrong binder here. If someone could take a look at that. Or maybe I'm, never mind, let me see here. Okay, I've got it.
Yeah, okay. So, this is in the matter of the Hente doing business as Hente 4 Abrams, case number 2018-0097. Procedural history: on July 18th of 2018, an individual named Marissa Franco, who is the co-founder of the Hente, which is a 501c4 social welfare organization based out of Arizona, filed a complaint against an entity known as Hente 4 Abrams. She alleged that Hente 4 Abrams, which was funded by her corporation, may have violated independent committee and campaign finance laws by failing to register and report their contributions and expenditures during the primary election of the 2018 gubernatorial race. It was, as I said, it was funded by the Hente, which is self-described as a organization supporting emerging leaders and candidates of Latin heritage. Following that election, an investigation was conducted by the commission into what, if any, activities Hente 4 Abrams undertook, what expenditures, what money was raised, to determine if there was in fact express advocacy, and determine in fact if there was a violation of campaign finance laws, and whether or not they should have registered with the commission and reported all of that information, those donations, those contributions, those expenditures. During the course of that investigation, commission staff subpoenaed and reviewed social media posts, digital media advertisements, mail and radio communications, organizational emails, evidence of paid canvassing on behalf of the organization which sought to elect Stacey Abrams governor in 2018. And staff determined that, in fact, Hente 4 Abrams did fail to register as an independent committee and did fail to appropriately report their contributions with the commission. Following, in particular, a review of relevant electronic communications, it was determined that Hente 4 Abrams began operating as an independent committee to affect the election of Ms. Abrams as governor on November the 8th of 2017 and continued through the conclusion of the May 22nd, 2018 primary election. Over that time period, during the primary election, the organization raised $240,250. Again, that's between November 8th and the primary election. Those contributions, and we'll outline those in a little detail later on, but they came from groups and entities located in New York State, State of Colorado, California, Rhode Island, and British Columbia. Just real briefly, I'm not going to harp on this too long, but a little relevant law. Independent committees are required to file reports on the first day of the 2 calendar months preceding the election. Then they're required to file a report 2 weeks prior to the date of said election. And then for that 2-week gap before the election occurs, much like candidates, any expenditure or contribution of more than $1,000 they have to file within 2 days. So those are the relevant filing periods we're talking about with this organization. So I'm going to walk through sort of a few different types of evidence that we discovered that verified that this was an independent committee that should have been registered and reporting. Here we see email communications between the Abrams campaign and the Mahente operation. And if you'll notice, these emails occur in October. And I go out in October of 2017 to arrange a meeting in late October of that year to determine whether Mahente would or would not endorse and advocate for Ms. Abrams' election. On November 7th, so a little over a week after that October 28th meeting occurred, a policy director from Mahente emailed the Abrams campaign and indicated that they will be endorsing Ms. Abrams for the Democratic nomination in the nomination and election of governor, and that they would intend to roll out a website and campaign with a field operation by early February. So by Mahente's internal records, which they provided pursuant to that subpoena, it was clear that they intended to go into the realm of express advocacy and electioneering. Here we see that on November the 8th, the day after they made the decision to endorse, they enter into the first contract during that time period with the subcontractor. In particular, this contract was with a design agency to build a campaign logo, sort of canvassing and digital print for the operation that they would run on behalf of Hente 4 Abrams. So like I said, we're going to talk about a few different types of electioneering evidence that was uncovered. Here we have, and this is, I'm not laying out everything, but I'm giving you a few examples of different types of electioneering activity. This is an example of print mailers that were sent out during that primary election for governor. And you see, of course, vote for Stacey Abrams, which triggers, and those are one of the 8 magic words, which triggers that it is electioneering communications. Another type of express advocacy and electioneering activity you see a lot of, and this will be true over the next few slides, is canvassing. There's a lot of paid canvassing that occurs. In these elections, and here we see on Facebook a boosted or paid for post to have people interested from Louisville, Kentucky, to caravan down to Atlanta and canvass voters at their homes during the weekend of May 4th through May 6th. And that was a campaign that Hente 4 Abrams titled Voto de Mayo, over the Cinco de Mayo weekend. So here we have solicitation for paid canvassers in Louisville, Kentucky. Here we have one in Columbia, South Carolina, and here we have one in Nashville, Tennessee. And this is another example of express advocacy through social media. Social media is actually a very interesting, development over the last decade or so in terms of campaign finance in the campaign realm. It's a great way for campaigns to get their message out, to build up support, but it's also a good way for us to track who's doing what because it is public. So this is an example of soliciting people to join sort of the organization and help elect Ms. Abrams governor during that primary election. And I believe this was for the same Voto de Mayo event. Here's a screen grab of digital media from that canvassing of those paid canvassers. And here we move into more of the financial side. So we've seen evidence of canvassing, but we also have to close the loop and make sure that that they're being paid to do this, that there's money being raised and expended. So, and I know it's a little small in print, but on this page, for instance, it looks like over the month of April for this clip alone, there's roughly $30,000 in expenses by the super PAC. They're itemized for things like paid staff, print and online ads, which we've seen a little of, Facebook posts that are sponsored and boosted, which you can do through Facebook, towards whatever target demographics you select. Facebook has that capability. It also includes things like radio ads, a little bit for website logos, literature design costs, and I think we even see, if I'm not mistaken, a Snapchat filter in this one or the next one. So here's another example of about $11,000 in expenditures that are spent on express advocacy and electioneering activity. Here we see that there is accounting for expenditures for a block of print and radio ads that were targeted towards Spanish-speaking radio stations and magazines. Because again, Gente por Abrams' targeted demographic was to turn out the Latinx vote as part of their push to get Ms. Abrams elected. So we see print and radio advertisements that they're pushing over this week period. And then here we have another block of expenditures. This one for a lot of canvassing, it looks like, in April. So we see that on this page of their disclosures, there's about $45,000 in paid canvassing during the month of April and early May. Again, all of this should have been disclosed in reports about where they were spending money and where that money was coming in from. So this is, we're going to have a couple of emails between the Gente for Abrams operation and iHeartMedia, which has a Spanish-speaking radio station in the Metro Atlanta area. This is detailing ads and sort of the mode and form where they want to target radio ads over the weekend leading up to the primary election on May 22nd. Again, all of this including express advocacy type language. And lastly, we see another, this looks like the follow-up email to tweak sort of the messaging. And finally, we see invoices for some of those mail piece expenditures. It looks like 6x9 postcards, 8x11 door hangers, processing, mailing, etc. So getting back to what is required to be filed and what was not filed, had they properly registered with the commission and reported where the money was coming from and how it was being expended, they would have filed a March 1, 2018 disclosure report, an April 1, 2018 disclosure report, a May 8, 2018 disclosure report. They would have filed 2-day business reports for anything they brought in or put out that exceeded $1,000 from May 9th to May 22nd. and they would have filed that June 30th disclosure report sort of as a supplemental to that primary election, all of which, of course, they missed. So the contributions after investigation that were not disclosed and properly reported, there was $30,000 that was contributed to Gente for Abrams on January 11th of 2018. That came from an organization called Groundswell Action Fund out of Oakland, California. $50,000 was contributed to the operation on January 30th of 2018 from, and I think I'm pronouncing that right, Vocal USA Philanthropy out of Boulder, Colorado. There was a large contribution of a little under $135,000 in February from the Advocacy Fund in Oakland. $1,000 on March 1st was contributed from the Fidelity Brokerage Service. On April 24th, there was $25,000 contributed from the Future Project in New York. And on June 8th, there was $20,000 contributed from Lush Cosmetics in Vancouver in British Columbia. And that's included because that would have been included on that June 30th report that they should have filed. In the consent order, like I said at the outset, the Gente for Abrams organization through Mahente, which funded it as sort of a side project, is admitting they failed to register with the commission. They're admitting they failed to properly file reports and disclose contributions received during the primary, and that they failed to file reports and disclose how they expended those dollars during the primary. They have agreed to pay a fine the amount of $50,000 for these violations. I can tell the commission candidly, there was a lot of negotiation, there was a lot of investigation in this case, but ultimately we agreed, and I felt comfortable that this was an appropriate fine. $250,000 in dark money was dumped into this race with voters not knowing where it came from. So that is significant. I think a significant penalty is appropriate, but at the same time, I do give Ms. Franco credit for self-disclosing that the operation they were funding was violating the law when she became aware that they may not be doing things right. So I think this is a significant penalty, but it balances all interests involved and recognizes both the issues and the violations that occurred, but also the effort to self-disclose and not hope we didn't notice it by Mahente.
Okay, who's 15? Commissioner Park, go ahead.
Thank you, Mr. Chairman. Mr. Secretary, I have a couple of questions for you.
Yes, sir.
So I want to make sure I have an understanding of how this particular issue came to the Commission's attention. So this is Mahente or Gente for Abrams self-reporting, correct?
Yes, sir. It is Marissa Franco specifically, who's the founder of Mahente.
Right, so this wasn't a complaint that was filed by a third party. They came to the awareness that they may not be in compliance with actively self-report, correct?
Correct.
And then the commission, after receiving this self-reporting, your office decided to conduct this investigation, correct?
That's correct.
Right. And so if you go back to the previous slide, the contributions that the investigations discovered, I just want to understand, so is Gente for Abrams, are they acknowledging or have they admitted to these specific contributions that were a part of your investigation, or are they simply acknowledging in a consent order that there were violations?
They provided us records that corroborated those numbers.
But in the consent order that I'm looking at, I don't see specific mention of these particular contributions. This is evidence that your office discovered, but they aren't acknowledging or admitting to these specific contributions. Is that correct?
I don't know that that's accurate. They provided those records. Consent orders don't necessarily spell out every single detail of every single charge. They acknowledge that they accepted contributions without disclosing it, and this is what those contributions were according to the evidence provided.
Sure, yeah, I'm aware of how consent orders work. I just wanted to make sure I had a clear understanding. And then the next thing is, how did you come up with the $50,000 amount?
So, no two cases are the same, obviously. You know that, everyone knows that. The commission considers cases like these and fines to assess to be proportional on a scale. It can be anywhere as low as 10% at times, it can be anywhere as high as 35%. Obviously, depending on the case, if it is a more nefarious case or if it is a more along the lines of a theft, things differ. This was about 20% of what they spent without reporting. Had they not reported, I would have recommended, had we found this on our own, I would recommend that I would not agree to anything but a much more substantial fine, which is something they have conceded is appropriate. They conceded that this is appropriate given the leniency on one hand and the severity on the other of what they did. They acknowledge that had they not reported, self-reported, this would be a much higher fine.
Okay.
And so that's how we came to that resolution.
All right, so there isn't any formula, so to speak, that your office applies?
There are general guidelines, but it's really bad practice to treat every case the same and say every case has to be handled this way or that way. That's a bad approach to administering a just outcome. So we don't have rigid guidelines like that.
I'm just noticing, the reason I ask is because later in our agenda, we've got another consent order and the fine is 10% of the amount of the campaign or undisclosed contributions, and I'm trying to figure out the difference between the case we're going to discuss next and this consent order, and why one is 20% and the other is 10%.
Well, again, no two cases are the same, and I'll say in a general sense, violations to this degree on a much higher level for a much higher office are more significant than hypothetically violations of a lower office where the impact may be important to a county, but not necessarily a state.
So the nature of the office being pursued is a factor that you consider, and so whether or not the severity of the fine.
Absolutely. There are a lot of factors to consider, but we're not going to treat someone running for the first term of the school board the same as someone running for the lieutenant governor. It wouldn't be appropriate to treat those two offices the same, and so that is absolutely one of many considerations we take.
Okay. I don't have any other questions at this time.
All right. And Commissioner Thompson?
Yes. Mr. Money, do we have an obligation to notify the FEC that foreign money was involved, either directly or indirectly, in an election, since it's strictly prohibited?
I believe, and I'll be candid, I have not thoroughly researched that issue, but that issue has been raised, and that is something I think we have an obligation to consider one way or the other.
And I'd like to speak to the commissioner's question about having a scale on penalties. There was a wonderful executive secretary back in the day who thought that was going to be a brilliant idea. And when he tried that, the commission just literally just demised the whole thing because it just didn't work. And we tried to, because we were just trying to show, or the commission was trying to show to be fair and stuff like that. We tried all kinds of different ways. It was just a terrible idea. From practice, or so I heard in the past. Thank you.
Is that a humble brag, Commissioner Thompson? All right, any other questions? Okay, but my only questions are, were they, Gente for Adams represented by counsel throughout the process?
Abrams.
Abrams, I'm sorry, yeah.
Yes, they were. They were represented by a couple different attorneys, but always an attorney at one point or another.
Okay. And was that attorney active throughout the negotiation process?
He was.
And has he consented to this consent order?
He has his signature with his Virginia bar number is on the consent order.
And has the executive director, or whoever the appropriate person is for Gente for Abrams, also consented?
She has.
Okay. I will move that we adopt the proposed consent order in the case number 2018-0097. Okay, we have a motion and a second. Any discussion? Okay. Any other comments, discussion? Hearing none, I will call a question. All in favor, say aye. Aye. All opposed? the motion will carry 4-1, and Commissioner Barnum is the nay vote. So next up, we've got, is Mr. McLaurin here? Mr. McLaurin, we moved you up. We amended our agenda to squeeze you in. I know you're busy passing laws, doing all sorts of stuff. So I will call your case number up whenever, and who is someone on behalf of the commission presenting? Okay. Good deal. Well, Mr. Cusack, if you could proceed, and Mr. McLaurin, is there a place for Mr. McLaurin to sit?
Yes, and if
Okay.
you want to sit there, I'll present, it's going to be a motion to dismiss from the commission, and then I'll let Mr. McLaurin speak as to what he's going to ask about for this.
Okay, go ahead. Thank you.
So this is case number 2018-0116. This is in the matter of Joshua McLaurin. This is a motion to dismiss from the commission. How this case began was on September 25th of 2018. The commission received a written third-party complaint from Roger Wise Jr., who was the complainant in this matter, alleging that Mr. McLaurin violated the act by failing to disclose legal representation that benefited his campaign. And he alleged that he violated the act in two ways. One, in an either-or type situation, that this legal representation.
Mr. Cusack, sorry, I forgot one more question. Is anyone on behalf of the complainant here? I want to give them an opportunity.
They will not be here.
Okay, go ahead.
So this third-party complaint stated that this legal representation either benefited the campaign as either an in-kind contribution or was an expenditure, and that this wasn't reported. This legal representation stemmed from a Secretary of State residency challenge that alleged that Mr. McLaurin was not actually a resident in Georgia and was not eligible to serve as the House District 51 representative. And obviously that challenge was denied because Mr. McLaurin is the representative for House District 51. So there was a hearing in front of OSA, the State Office of Administrative Hearings, where it was determined that Mr. McLaurin was eligible to run and stayed on the ballot. After that hearing was held, this complaint was filed, which then alleged that this legal representation benefited the campaign and wasn't reported. Now, during this residency challenge, Mr. McLaurin was represented by Holcomb and Ward, and the scope of that legal representation was various filings and representing him in front of an administrative judge in OSA. That legal representation is the crux of this complaint, and that's where this complaint centers on. This legal representation was never listed on a CC1. It was never listed as an in-kind contribution or an expenditure. Now, after this complaint was filed, Mr. McLaurin filed a response in which he provided the commission with documents and evidence of that legal representation, and that was pro bono legal representation, also in his personal capacity, as his residency was being challenged, not the campaign's residency was being challenged. So there was no duty to disclose there because it was actually benefiting him personally, but also this was a pro bono representation. So that did not need to be reported. So there's a two-pronged approach you can take on this, and why the commission is asking for it to be dismissed is that either this was pro bono, it didn't need to be reported anyways because this was volunteer basis. Also, it was Mr. McLaurin's personal capacity that he was represented. It didn't benefit the campaign, but it was actually for him as a private citizen or as a citizen of House District 51. So that's why the commission is asking this to be dismissed. Mr. McLaurin is going to ask for a finding of frivolousness here, and I'm here to answer any questions about it, but that's why this would normally be an admin dismissal based on the documents that Mr. McLaurin furnished the commission. We were able to determine there was no violation of the act here, since this was either pro bono representation on a volunteer basis and also in his personal capacity. But Mr. McLaurin is going to ask y'all to make a finding, and so that's why this is being done as a motion.
So you're all in motion, though, as a motion to dismiss?
Yes.
Okay. So do the commissioners have any questions, comments? What was so the complainant's not here, were they put on notice?
Yes.
Are they represented by counsel?
Yes, I believe Mr. Brian Tyson filed the complaint representing or filling out the complaint for Mr. Wise, who was actually the complainant.
Okay, and he was put on notice?
Yes.
And he's not attending?
That's correct.
Okay. Well, hearing no opposition, I will make the motion that we dismiss the complaint in the case number 2018-0116 in the matter of Josh McLaurin.
Second.
All right, we have a motion, and a second. Any discussion? Is that you, Secretary Amati?
Point of inquiry, I don't believe in, correct me if I'm wrong, I don't believe you can dismiss the case before you hear the argument on frivolousness to make that finding.
Yes, and Mr. McLaurin would like to address about
Are
frivolous.
they two separate motions?
Essentially, yes.
Okay.
So I'll speak to that for a moment. The reason it's being presented as a motion to dismiss is because if we add and dismiss it, there's not an active case that you can attach the frivolous argument to. You can make a finding of frivolousness after the case is closed. But if you make a motion to dismiss and you have a motion for a finding of frivolousness or not, you can vote on whether it's frivolous or not, have that finding in the active case, and then close the case with a dismissal. I believe that's the proper procedure.
Mr. Chairman, I think we probably do need to hear the arguments on frivolousness so we can close it out completely. As Mr. Amati said, I agree that we should probably hear that.
Yeah, I have no objection to hearing it. And maybe I'm thinking too much the way a typical court works. You're not going to get a motion for attorney's fees or frivolous until the case, a judgment has actually been decided that is dismissing the case. But procedurally, it's inconsistent with typical rules. Is that the case?
I will concede on the record, I have never had to argue for attorney's fees, so I'm a little out of my depth here. I'll defer to the subject matter experts up here.
Yeah, well, the typical way is first you're going to get a judgment, and then you're going to have to decide whether, based upon the judgment, because if we dismiss if we do not agree to move forward with a motion to dismiss, then the frivolous has no basis. If we do agree to move forward, to me, that gives the predicate to then hear whether it was frivolous. Are you okay with that, McLaurin? Okay. Or Representative McLaurin? Well, I propose that's the way we do it, just because that's the way we typically do it. And so I'll make that motion, and then after we've made that motion and decided, if it's granted, then Representative McLaurin, you'll have an opportunity. Okay. So any other discussion? We currently have a pending motion. Hearing none, I'll call the question. All in favor of granting the motion to dismiss, say aye. Aye. All opposed? Motion carries. Case has been dismissed. We will now hear Representative McLaurin's motion.
I really appreciate the commission's time, and particularly the Civ Pro debacle that we just went through. I appreciate y'all being willing to do that. I'm here today for a very simple reason, and that is Minority Leader of the House called my campaign the nastiest campaign in 2018. And the way that it operated was that the opposing party funded a mail campaign that was predicated on 3 administrative complaints that were opened by lawyers who were affiliated with the opposing state party in some sort of formal counsel role, or affiliated with lawyers who have formal counsel roles, to initiate these complaints against me in my individual capacity, such that mail could be run saying that there were open investigations into me, and they were called criminal investigations, which is why I actually initiated a libel suit that was settled about 2 weeks after I initiated it, for the purposes of trying to persuade voters or deceive voters into thinking that I was somehow under indictment, or that the DA or the GBI had opened a file. And so this commission was commandeered by this complaint, by Mr. Tyson, as part of a mail strategy to weaponize the complaint such that my reputation would be besmirched, etc. Now, I tend to think of myself as a fairly modest and easygoing guy, and I'm not here just to vindicate how I felt in 2018, which frankly was bad. But I'm here because I think the commission has an opportunity to set a standard for which complaints are valid coming from private citizens and which are not. This complaint, I believe, is frivolous in 2 ways, and I'll direct you to OCGA 2156B23. That creates a duty for the commission to do a frivolousness determination. So what I believe is that, and I don't know that there's administrative guidance on the meaning of frivolous or case law on this, but I would contend that just on the plain meaning of frivolous, there's 2 reasons that it is. First is this commission has the authority to determine that something's frivolous if it lacks a legally valid basis. Now, the complaint as a whole, actually, I spoke to Mr. Mahdi, I think that it's possible to say, well, we haven't seen the expenditure contribution reports, so we should figure out if Mr. McLaurin paid for these services. But that allegation was not in the complaint. The complaint was purely about whether a law firm, Holcomb and Ward LLP, was a person for the purposes of the Ethics in Government Act, right? What could a person provide legal services if a person was Holcomb and Ward LLP? On the face of the statute, that issue is not reasonably contestable, right? Holcomb Ward LLP is a person under the plain language of the statute. It's an LLP, and it's a person that had a record agreement with me, provided legal services. I explained this to Mr. Tyson in a letter I sent to him shortly after. It's not the record, unfortunately, but he did not withdraw the complaint, and I think in retrospect it's obvious why, because all he needed was for the complaint to be open so that his client, or at least the beneficial interest who wanted the complaint open against me, could prosecute a mail program. So the first reason is, on the face of the complaint, the legal argument advanced. I don't think any reasonable court or tribunal could accept it. The second reason I think it's frivolous is I think that this commission has the power, under the meaning of the word frivolous, to do a bad faith analysis, in essence, and analyze the reasons why the complaint was filed based on the record. And there is a record of the mail program that was run against me. I sent it to Ms. Wetzel, I think about a year and a half ago, and it should be in the record. It's got a number of exhibits that show the specific mail pieces used to exaggerate what was happening before the commission, before it had even acted. In fact, at one point, Ms. Wetzel granted me an extension on a response filing, and that extension email, which I think asked Ms. Wetzel to copy Mr. Tyson on, was then carbon copied in the mail program itself. So even Ms. Wetzel's correspondence on routine business became a part of the attack line, which was he's been granted a continuance on his ethics hearing until after election, as if to sort of stir a conspiratorial allegation about why I might have done that. So again, I don't take too much pride in my circa 2018 reputation. I'm just here today because I think it would really serve the maintenance of elections, or the administration of elections in Georgia, and it would encourage candidates, good candidates, to run for office who don't feel that they have to walk into a government, manipulation of government, a maelstrom like this, just to run for office and represent their communities. I'm not asking for actual fees. I spent 3 hours of my own time, but I didn't pay anybody else anything. But I believe the commission has the authority to make a frivolousness determination on the record and then award an amount of zero in fees, just so the commission can go on record, setting a precedent that this type of specifically bad faith complaint cannot be a use of the commission's time. Thank you for your time. I'll be happy to answer any questions.
So I'm not weighing in on this, but for edification for the commissioners, on page 8 of your binder you have here of the Campaign Finance Act, subsection 23 of 2156, that's the right and power you have to award attorney's fees. And if you go to page 7 of the rules, number 9 is a frivolous complaint definition. So that's what you would evaluate whether this was frivolous or not against. And that is, of course, the rule and definition that you all adopted late last year.
Commissioner Watts?
So, just to be clear, we did get through this process, right? Okay. And this is the new.
Are there any questions? Because I have to run to a vote. If not.
There probably will be.
Okay.
They won't be super long, but there will be some. Do any of the commissioners have questions? I have a couple, but my first of all, just to state emphatically, and you're not the first time Representative McLaurin, this has came up, politically motivated ethics complaints are not going to be tolerated. They should not be done. I've seen the materials in your case, and I empathize with your frustration. We adopted this attorney's fees provision for instances like this. My biggest concern is you're not pursuing attorney's fees, right?
I would, in theory, pursue attorney's fees for my time, but my understanding is that the rules you promulgated don't allow that claim. So I didn't want to waste your time with it.
Yeah. My biggest concern is we make a finding of frivolous to create a justification or meet the standard to award attorney's fees. I'm uncomfortable with the commission just making frivolous claims when there's not necessarily a justiciable issue. And that's my concern, and I don't know if any of the commission staff want to opine on that. And if you guys have an opinion one way or another.
I think it's relevant into how we open up cases at the commission, whether or not we accept them or not. If there is a complaint that comes in that is that alleges a violation of the Campaign Finance Act, we accept that complaint. Now, if it's a complaint, an ethics complaint that says so-and-so cheated on a test somewhere, we reject that. So whenever a complaint comes in and there's an actual and it alleges a violation of the Campaign Finance Act, we then accept that. So it creates a tough question for us whether we have to accept these cases. We don't know if they're privileged or not. We have to do an investigation because it alleges a violation of the act. So that.
No, I understand that point, but my point is, do you have an opinion on just making frivolous determinations when a party is not pursuing attorney's fees?
I don't think that's what the adoption of the attorney's fees, when this commission adopted it, I don't think that was the point of it. That's all I'll say to that.
Okay. And do any of the just to keep us on topic, does any of the commissioners have comment on that?
Representative McLaurin, are you an attorney?
I am, sir. Yes.
Okay, and you practice
Yes, sir.
when you're not in session?
And when I'm in session, sir.
Right. How much do you charge an hour?
My going rate is between $3 to $3.25, depending on the matter, sir.
And you said you spent 3 hours of time.
Correct. And originally I was going to ask for $900 in fees.
Okay, so, Mr. Chairman, from my perspective, if we have a finding and we believe that this was frivolously filed, whether or not the prayer for relief is seeking fees, and I respect the fact that the Representative McLaurin is not seeking fees because he probably wants to take the higher road.
My constituent filed the complaint, sir, and I have no reason to get a pound of flesh.
I understand that.
Exactly.
But from my perspective, this commission can send a message that we won't tolerate this type of politically motivated these complaints and weaponizing for political gain what is supposed to be an apolitical process. So I would absolutely feel comfortable awarding fees of $1,000.
All right, Commissioner Watts?
So, we talked about notice earlier, and I may have missed this, but the complainant was put on notice that this dismissal would be heard, right? Was the complainant put on notice that a motion for a finding of frivolousness would be heard? Because that's what the motion was first, wasn't for attorney's fees. So now we're changing it, and I'm happy to have the debate about whether we should do it, but we're totally changing what the game was when we started this.
Secretary Monty?
So, Commissioner Watts, procedurally, Mr. McLaurin, Representative McLaurin filed a motion to dismiss this case, saying it was not valid. Within that response to the complaint, he also included a motion for attorney's fees, and counsel for the complainant was made aware that this was for both. And he said
So
that
there was a motion for attorney's fees.
there was a motion made. Representative McLaurin made the motion for attorney's fees for the job.
Okay.
Have you communicated with the counsel for the complainant?
The only time was when I sent a letter soon after the complaint was filed, sir, and I said, I really believe your complaint's frivolousness, and I intend to seek fees under the provision. I said, if Mr. Wise refuses to withdraw the complaint within 3 business days of this letter, that was September 28, 2018, I will respond to the commission's notice of this complaint with a letter seeking attorney's fees under, and I cited the OCGA provision. And he responded with an email. Again, I apologize, it's not the record, but he said he didn't believe that that my position was valid.
But he was on notice. I want to just emphasize this point. A motion for attorney's fees has been filed against a party with an attorney representing that party, and they have not attended the hearing. That is beyond my conscionability. Have they? So there's no doubt that they're on notice. Mr. Cusack?
Yes, Mr. Chair, you were on notice.
Okay. Well, yeah, go ahead, Mr. Commissioner Cranville.
And I'm sorry,
to interrupt on that, but I just want to check on this. What exactly, and again, I'm not trying to beat a dead horse on this either, but what exactly were they on notice of, and where can I see the notice? Again, I'm not particularly a fan of imposing some type of order of attorney's fees on someone when I haven't seen evidence of the notice that was going to be addressed today.
Sure, and that's a good important question. Representative McLaurin, we're trying.
Yeah, we are.
We got a lot of
This is my
different
first vote of
brains.
my term just now, so that's how important I feel that this is. quite
Okay,
frankly.
okay, well, thank you, thank you.
I mean, I guess, I'm sensitive to your situation currently. So, I mean, one thing we could do, I'm not making a motion to do it, but we could table this issue for attorney.
I disagree, if you're put on notice, I can't, I mean, that's beyond me. I mean, it's up to the commission. The first question I think the commission has to answer is, if you're not pursuing attorney's fees, do we just make determinations of frivolousness? Because that's gonna set a new precedent.
So my response to that is no, unless that's a proper motion. I mean, as far as I can tell, I don't think it's appropriate for us to just make findings that, lead to nothing and have no result. So I was unaware until we just talked about it, that this was the true motion for attorney's fees, which I'm fine with discussing. I think to Commissioner Cranjo's point, what does the notice look like? That obviously I raised the issue first, so I'm concerned with that, but
Yeah, please, the notice is the most, I would like to see that. Commissioner Barney?
No, I was gonna make a motion, but I agree, we should get evidence of the notice, because then that will inform my motion.
I mean, the thing, Mr. McLaurin, is what you just said is you're missing your first vote to be here. There is no way in the world I'm gonna support tabling something. If someone was put notice that this was taking place and they failed to appear. I mean, so that's not gonna happen. You don't have to worry about that. So the question is just, we need notice. If you guys, one of you guys trying to find that? Okay. Commissioner Thompson?
So my question comes that this is administrative dismissal. We have numerous administrative dismissals coming up. Have we done a due diligence to show that it truly is frivolous, or are we saying because, are we moving the ball because if, let's say, notice was given that the attorney didn't show up or the complainant didn't show up, what have we done to show, to say it's frivolous? Is it the staff's opinion that it's frivolous? Are we all upset because it was used in a political mail piece, which we always know these usually are whether opened up? And I'm not saying it isn't frivolous. I'm just trying to figure out, how do we determine it's frivolous?
Well, to me, the first question is, do we give, if you're not seeking attorney's fees, do we make those determinations? And then if we answer yes or no, that determines the next point. Has anyone made an argument it's not frivolous? I haven't heard one.
Mr. Chair, I'm happy to make one. In fact, this is something I had thought about in advance of this hearing. I would like to make the argument, if the commission is welcoming that argument, that the regulations promulgated by the commission don't line up with the statute. That any regulation that says I'm not allowed to seek fees for my own time when I can show a market value for that time is inconsistent with the statute. And so because I'm making that argument, if you welcome it, I would say that you could theoretically stage your analysis into two parts, make a frivolousness determination first, and then take up the legal question that I have presented, which is whether my fees claim is valid under the statute.
Does the staff have an opinion on whether, if they've done it pro bono, can we award attorney's fees in that situation?
It's dangerous for staff to weigh in. When we have a case and do an
And
investigation.
if you have no opinion, you have no opinion. I'm just,
I will say this, and I'm going to be very careful in what I say because, again, I'm not advocating for one position or another here. But I think the commission has to contemplate that. Look, when I took over, I said, we're not going to allow these complaints to be weaponized. And I mean that, I believe that. At the same time, I think we have to consider what the effect of finding frivolousness and awarding attorney's fees against a citizen who I think a colorful argument could be made, was not aware that the representation was pro bono. And Mr. Representative McLaurin makes a good argument in terms of how the complaint was filed by the attorney. But the only thing I would ask you to consider is, if we begin assessing attorney's fees against citizens who don't just assume the representation is pro bono, does that have a chilling effect? I think that's something to consider.
Was it individual filed the complaint, or did they file the complaint with the attorney? Because if they filed it with the attorney's job is to know whether or not there's a legal basis. So was the complaint just filed by a citizen, or did the attorney help?
Representative, I believe Mr. Tyson filed it on behalf of with law firm.
All right, Commissioner Barnes.
Sure, and I just want to go back to the pro bono versus value. Just because services are being provided pro bono doesn't mean that they don't have value. Any practicing lawyer understands that when you provide pro bono services to a client, it's because you've reached a fee agreement with the client that you're not going to charge them for the time, but it doesn't mean that the time doesn't have value.
And I agree with that. I don't know if the case law says that if you haven't, my instinct is it says no, but I haven't looked it up, but no one's here to present differently. So what's before the commission, and the reason why sorry for my frustration. I remember when a motion for attorney's fees was filed against a complainant who lived in LaGrange, who was a nice old lady, and she showed up to oppose that motion, and the motion was eventually denied. To me, the fact that you have a motion for attorney's fees filed against you and you don't show up is a pretty strong indication, number one, of how seriously you take your own complaint, and number two, how seriously you take this process. Each of us are busy people. We're here giving up our own time. For you not to show up and oppose a motion for attorney's fees is not taken kindly by me. And I don't want to argue the other side's case for them, but the fact of the matter is, I am, to be frank with everyone, I'm more comfortable, if we're allowed to do so, awarding attorney's fees, making a finding of frivolous and awarding attorney's fees than just making a finding of frivolous. Because my concern is that I don't think we should just make findings of frivolous when there's no relief being sought in that regard.
Mr. Chairman, I want to echo your thoughts, and I will add this. A finding of frivolousness without more is no finding at all, in my view. And so, have we been able to determine, Mr. Cusack, have we been able, or anyone from the staff, have we been able to determine that notice was in fact given?
We're trying to find it right now.
Okay. Well, then I am prepared to make a motion. Well, I'll go ahead and make the motion. I move that we find that this complaint was filed in violation of the act, was frivolous in its nature and its intent, and award attorney's fees in favor of Representative McLaurin in the amount of $1,000.
My amendment to that is we've got to get an affidavit that supports, with any motion for attorney's fees, you've got to get an affidavit that supports your rate is X, Y, Z. You swear under oath you allocated 3 hours of time. So I will amend the motion to that effect.
And I'll accept that amendment, and maybe we use it, subject to Representative McLaurin presenting an affidavit of the value of his time and the amount of time he spent.
Within 7 business days, I would say.
Yes, sir.
Okay, so we've got an amended motion. We've got a second to that. Any discussion? Good.
I mean, look,
Representative McLaurin, I'm extremely sympathetic both to your time at the moment and the fact that the time that you put into this effort. And I have my own views about whether this is frivolous or not. I am not going to vote yes on a motion such as this without an affidavit in front of me, and without seeing the notice itself. But I don't want that to be, in your view, taken as me not supporting it. And it's not your fault. It's not here. And I think that this may have turned into something more than it originally was intended to be. So that's my view on it.
Go ahead, Commissioner Cranfield.
I was waiting. I was waiting a moment because I thought that they found the notice. I'm not as, perhaps the affidavit is necessary. I don't know if it's in the rules that says that it's necessary. I'm not as concerned with that because I think that I've seen many times where people are asking for attorney's fees that you could state in your place what your rate is and how much time you expend in the case. So I'm okay on that part, but I don't necessarily oppose that part of the motion either. But as I think you probably understood from my comment to this point, I'm a little bit concerned about the notice. And so until I can see that that notice was actually given to the other party, unfortunately, I'm not going to be able to vote in favor of it either, but I have a feeling that that may change based on something that's on this computer.
As of right now, I don't see, we don't have a copy of the notice. Mr. Amati may be able to speak differently to conversations he's had, but I do not see a notice of attorney's fees. It's for a probable cause hearing. So that may make the matter easier.
So the problem we're having is we have had to retrofit this room in the tech to live stream, to set up for Zoom. We've had to increase bandwidth. So and this was earlier, I can't VPN to our actual system. So I don't think we have the access to VPN yet. That having been said, and this is not certified mail, but I have had conversations about this with Mr. Tyson. So,
Well, we got
and I understand that's not legal notice.
Mr. Chairman, I'm prepared to withdraw the motion. Not because I don't believe in it, Representative McClellan. I think you understand where at least Chairman Evans is coming from. I do think we need to resolve as definitively as we can the issue of notice, and perhaps we come back and once we have notice. And I don't think I need you to come back, Representative Fund. I don't want you to, although there's only, 9 more days, so I don't think we're going to convene in another 8 or 9 days. But perhaps we can table this till our next meeting until such time as we can resolve the issue of notice.
May I say one thing? I want to have this conversation.
Yes.
And so I would support tabling it and having the conversation because we changed the language of this rule for a reason. And I think we should have that conversation. But, for events beyond our control, I don't think it's appropriate to have that.
And so if I may, Mr. Chairman, I move that we table the question of frivolity and fees with the following understanding that we will not be hearing any arguments on the question from the other side, because on the underlying issue of dismissal, because today was the day to make the appearance and opposing the other side, Mr. Wise or his counsel did not appear. So I want to open up this question on the underlying issue again.
Perhaps another way to put it is that we, a motion to adopt the dismissal and then a motion to table the motion for attorney's fees.
I'll accept that amendment.
And if I could make a point,
Hold on, we got a pending motion. Is there a second?
I think if I accept the amendment, does Commissioner's amendment constitute a second?
I think you would, you could second it.
Okay,
Because it'll make a new, Okay, we got a motion and a second. My concern is we can't forestall the complainant's ability to present argument if they haven't been served. And if they have been served, I feel comfortable with that. But we have to make sure they've been served.
Mr. Chairman, I think that there is evidence that they were on notice of the motion to dismiss,
Correct.
but they just weren't on notice of the attorney fee motion. So the first half of the question, the administrative dismissal, that is something, and I think that was the point of what we were just talking about, is that is something that is now done and completed.
Yeah, that's right.
Now, I would like to add that if we find out that there was no, that we tabled this, and we find out that there was notice, and this goes to your point, Mr. Chairman, and we table it, we come back at the next meeting and address this, then I don't think that the respondent to the motion for attorney's fees should have any opportunity to come in and argue in opposition to that. That's just giving them another opportunity when he should have been here today, if we find out proper notice was given.
I'm happy for him to come in and be telling that.
Okay, so we just to clean it up, we've got the motion's dismissed, granted. It's been, the complaint has been dismissed. We now have a pending motion. I'm just going to restate the motion as chairman. The pending motion is, tell me.
So if the motion to adopt the dismissal has already been granted, then the pending motion is a motion to table the motion for attorney's fees until the next meeting.
Are we adding any contingencies to that consistent with what Chairman Cranfield just said?
I can offer, Mr. Chairman, that if someone shows and attempts to argue, I think we can address that attempt at the time.
Okay, yeah, I think it'll work itself out.
Agreed.
Okay, so we've got the motion to table, that your motion for Phyllis and attorney's fees. Mr. Commissioner Barnum has seconded it. Open for discussion. In the meantime, I would do your best. You're going to be on the next commission calendar, which is in August. With notice of this hearing, of that they were on notice that you filed a motion for frivolousness and for attorney's fees. Please try to present that to the commission. I think we also need to make sure they get notice again that they're up in August. We invite them the opportunity to come. And so with that, any other discussion? Okay, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Motion carries. Representative McLaurin, I hate that you have to come back, but thank you for coming.
Thank you for your time. We know that the process is long, but worth it, so thank you.
That's right.
Hopefully you're not still in session come August too.
All right, the next item on the agenda is case number 2019-0024 PC in the matter of Neil Warren. And who on that, after the commission's handling that? Secretary Motti, please go ahead.
Gentlemen, this is another consent order in a case that was filed by the commission sua sponte following a random regular audit of select officials in Cobb County at the time. This is a consent order wherein Sheriff Warren, the sheriff of Cobb County, is conceding that he converted some campaign resources to personal assets, but that he also converted public agency resources to campaign assets and failed to disclose some in-kind contributions. And for the record, Mr. Chalmers is counsel to Mr. Warren. Mr. Chalmers indicated, and we'll see. My understanding was he was going to attempt to call in, but was not coming in. So.
He's here, sir.
Okay.
Let me put it on.
Can I go ahead and ask a question?
Sure.
Is it usual or unusual? I'm sorry, Mr. Chair, I should ask you. Go ahead. For Mr. Chalmers not to have signed the consent order? Or is that not typical? Or maybe I'm just thinking different.
We have.
Hold on. They can't hear you yet. Hold on.
it's not required. Typically, Mr. Chalmers, I believe, would himself in his practice, but all of this was going on during the pandemic, so that threw a wrench into it, but it's not technically required if they're fine with it.
I mean, I was actually gonna ask, when I didn't see his name on this, if he was no longer represented.
Right.
So is Mr. Chalmers via Zoom or?
Zoom, via Zoom, sir. Hold on.
I mean, from,
Is he gonna show up on the
He
big
cannot,
screen?
he cannot. I mean, hold on. Doug, they can't hear you. Hold on, please. Let me transfer. Give me a second. It's connecting right now. Okay, speaker. Right. Okay. All right. Right. Doug should be. Okay, Doug, they should be able to hear you now.
Doug, are you there?
Yeah, he's here. It's on. That's fine. Hold on. Yes. Yeah, let me turn this thing off. Okay, can you talk now? Yeah, let me turn this thing off. Okay, can you talk now? You probably have phone. You probably have phone.
Oh shit. Don't you just click?
Yeah, it should be.
Yeah, just hit start video. Right there.
Yeah, yes, Doug, I can hear you, but it's not showing up on the computer audio. There you go. Okay, now they should be able to hear you, Doug.
All right, can you hear me now?
Yes, Doug, I can hear you, but it's not,
It's a delay. It's good. Okay.
It's Doug.
There's gonna be a delay.
Doug. They should be able to hear you, Doug.
All right, can you hear me now?
Yeah, it's on. It's on right now.
All right, we're gonna go ahead and get started. So hopefully Doug doesn't have to say too much here, but, well, not to say it. It's a consent order. We've heard Doug many times. We love his voice. All right, Secretary Marty, go ahead.
So,
So, a little bit of procedural history, and like the last one, this will be a relatively short PowerPoint. I'll try not to belabor any points, but as I said, there was an audit of a number of Cobb County elected officials. Sheriff Warren was one of those. During a review of his records, we noticed there were a number of discrepancies and things that didn't really make any sense in terms of his expenditures, which he had a number of expenditures.
Erwin, can you hear me?
Yes, sir. You are already live, Doug.
Erwin.
Doug, you're already live.
In any event, there were a number of petty cash expenditures with no description of what it was, anywhere from $100 to $500. We conducted a preliminary audit based on that and conducted a notice of inspection on August the 2nd of 2019 to inspect records which within the campaign that they were statutorily required to keep for 5 years from the date of transaction, because he held a 4-year office. Following that preliminary audit and notice of inspection, a complaint was filed on October 2nd, alleging that a number of expenditures were not used to defray ordinary and necessary expenses to the campaign, that some campaign assets have been converted to personal use. And I'll point out, and this becomes relevant, many of the transaction expenditures at issue, along with the bookkeeping, which was, and I think Mr. Warren will acknowledge, the bookkeeping was a big problem, understanding what was going on. And part of this consent is they are agreeing to sort of come into the 21st century with bookkeeping. But a lot of the transactions and expenditures revolved around the corn boiling, which is an annual fundraiser that the Cobb County Sheriff conducts jointly to raise money both for his campaign and for the local youth museum. And the sheriff pledges to help raise $10,000 to the youth museum through this corn boiling every year. And if the youth museum does not solicit that $10,000, his sort of premise of this joint fundraiser is he bridges the gap. So here, for example, is a flyer from the 2019 corn boiling. It was on Monday, January 15th, from 5:30 to 7:30 at 10 Miller Park. This is an event, as it says, the 30th annual event. This is an event they've been doing for years. Predating this sheriff, in fact, I believe his predecessor as well. This is sort of one of the angles of turnout from the 2018 corn boiling. So you see pretty heavy turnout. It effectively is his main fundraiser each year. On audit, once we were able to sit down and really start to understand the bookkeeping and the transactions, we were able to sort of ferret out what was what. And we were able to uncover through some electronic communications that individuals who work for the Cobb County Sheriff's Office as staff were performing campaign functions while on duty at the Sheriff's Office, which constitutes a violation of 21.5-30.2, but it is an acceptance by the campaign of a public agency contribution, that being the Sheriff's own agency. And here is some statutory language that prohibits an agency or person acting on behalf of the agency to make that contribution, and likewise in subsection C that the campaign committee cannot accept that contribution from an agency or a person involved with a public agency. So here's an example of an email correspondence between a Ms. Young, who was the executive assistant to the sheriff. You see that the email correspondence is with people involved in the fundraiser itself. It is sent from the county email address, the sheriff's office address. It is sent on Wednesday, May I believe that says the 8th, at 12:53 p.m. So it's in the middle of a work day. And again, like the last PowerPoint, I'm not putting all of the items, these are just indicative of some of what we saw. Here we see another email from the executive assistant of the sheriff to someone at the youth museum about pictures of Marion Daily Journal in conjunction with the fundraiser of the corn boiling on Friday, July 6th. That email in correspondence and sort of operation of organizing this was sent on Tuesday, July 3rd at 4:43 p.m., again during a workday. As I said, the sheriff has acknowledged that employees of the sheriff's office made purchases for purposes of organizing and facilitating the corn boiling while on county time. An example of that would be, so this is a record, sort of internal records of one of the corn boilings. You see that a couple of officers within command staff were tasked during the day with setting up photo shoots, getting with local press, picking up food. Sort of the highlighted version at the bottom, and this is what I meant when I said that there were also in-kind contributions. And there were not a lot of these, but there were some in-kind contributions that had not been disclosed. So I believe 10 gallons of ice cream was donated. Sodas from Pepsi were donated, 1,800 sodas on July the 9th of that particular year to store until the event, the fundraiser on the 16th. In the consent order, the respondent did see improperly accepted contributions from employees of his agency who contributed to the campaign while on agency time, that some campaign assets were converted to personal use, and I'll speak to that in a second, and that he failed to disclose in-kind contributions by members of his staff who did a few things here and there on county time, purchasing things, setting things up. Initially, because the bookkeeping was a mess, it was unclear what was what. And so the original complaint alleged about $19,000 in campaign expenditures that were converted to personal use. We always understood that once we understood the books better, that number would likely be lower. Some of those were still converted to personal use in terms of meals that occurred 6 months after he got reelected. Others are quite common where a candidate for office 3 months, 6 months during an election year will go out with constituents, go out with campaign staff as part of the campaign and pay for food. That's perfectly acceptable. But where the delineation is where it clearly doesn't relate to the campaign and a re-election bid, because that is 3.5 years away. And the sheriff, to his credit, the sheriff has acknowledged sort of what I'm speaking to. So with all that in mind, we agreed to a fine in the amount of $10,000 for said violations. I think that's an appropriate figure. I think it's for a countywide sheriff, I think that's a significant fine. And we would ask the commission to adopt the consent order as Mr. Chalmers, his client, and I have agreed.
All right, Mr. Chalmers, can you hear us?
Yes, sir. Can you hear me?
We can. Mr. Chalmers, do you have any additional comment or insight?
Yes, sir, and I will try to keep this short. Couple observations. This is a case that arose primarily because of the very unusual nature of the corn boiling event, which is a fundraiser that has become a Cobb County tradition that began in the 1990s. It is a hybrid event. It is both a fundraiser for a 501c3 charity, a nonprofit, the Cobb County Youth Museum, and also has been for the sheriff's campaign committee going back to previous sheriff. As a result of that, I think that some of the employees in the sheriff's office became confused about what they could and could not do during office hours. A number of emails were sent organizing the event during office hours. I think it's important to note, as the consent order expressly states, only 2 of those emails were from the sheriff personally. The vast majority were from staffers who were enthusiastically working on helping to put the event together. The sheriff has decided to accept responsibility for all of that, and the campaign committee as well, and has agreed to pay the penalty for that. We've also, it was our request that the commission staff come in and do an hour-long training session for employees of the sheriff's office, so that going forward, it's very clear delineation of what can and cannot be done during office hours for anything like this sort of an event. So I don't anticipate these sorts of issues, which are, again, unusual in my experience, will pop up again, given the nature of the event. It is undisputed that every year, since this event has been going on and Sheriff Warren has been involved in it, the Corn Boiling fundraiser raised $10,000 for the Youth Museum, which the sheriff personally guaranteed either from contributions for the event, directly from the event, And if they didn't get 10,000 from contributors, he would make up the difference, and that is in fact what happened. One of the things I think that caused a lot of problems for the commission staff, and understandably so, is that the campaign has historically used a petty cash system that was a little bit unusual in the way it was reported. Because the treasurer of the campaign committee is an accountant, he used accounting principles to report petty cash expenditures. And so, for example, when cash was taken out of the campaign account, it was reported both as a contribution and an expenditure, which really wasn't technically accurate, and that won't be occurring going forward. I do want to take issue with one thing Mr. Amati said. Mr. Amati said that the sheriff and the campaign have conceded that campaign funds were used for personal use of the sheriff. That's not accurate. Consent order says nothing of the sort. A number of the expenditures that were made by the campaign were contested by the commission staff. Some of them, well, the ones that Mr. Amati referenced, were for meals. Many of the expenditures were for food and beverages for the staff of the sheriff's office, and campaign funds may in fact be used for official expenses. We disagreed on that one. There were, however, other expenditures, a couple of them which were used for things that appear to be personal use of staffers, not the sheriff. And so for that reason, the consent order does say that the sheriff, the campaign committee, the sheriff concedes that certain expenditures were not for ordinary and necessary campaign expenses. The consent order that we drafted does not contain a violation of the personal use provisions, and nor do we concede that with respect to the sheriff. And so I must take issue with the way Mr. Amati has characterized that portion of the order. I do think that the most significant part about the order was the email on county time, and that's the principal reason that we are conceding to the order. The sheriff and his treasurer have gone to pains now to revise the way they are conducting the campaign's operations, and I do believe that the disclosure reports going forward will be clean and correct, and we look forward to the training session that the commission staff is prepared to offer to the sheriff's office employees in the near future. That's all I have, Mr. Chairman.
Okay, thank you, Mr. Chalmers. And Mr. Amati, you have a response?
At this point, we've agreed on a number that we think is appropriate, okay? And if I'm not really inclined to pick a huge fight about a Zaxby's order here or a Chick-fil-A order there, the order speaks for itself that there were, expenditures that were not for ordinary and necessary reasons. And I think at the end of the day, there is acknowledgement that a number of violations occurred. There's agreement that the most significant was the public agency contributions, using the resources of your office for the campaign. We agree there. I'm not inclined to pick any fight over this. I think this is a consent order that speaks for itself, that there is general agreement. I think we can go ahead and vote on it. I don't think getting in the weeds is necessarily worth it there. And I would just leave it at that. Okay,
Commissioner Barnes?
Yes, Mr. Secretary Amati, what's the total expenditure here, the improper expenditures, based upon your audit, what's the dollar figure of this year?
We didn't, and Mr. Chairman, yeah. And Mr. Chalmers, I think, can corroborate this. Ultimately, the votes were such a mess. We agreed that a lot of the meals that were clustered around an election, I agree with Mr. Chalmers, it's very common. We felt that in the aggregate, $10,000 was a significant fine for this case that balanced all the issues and was a fair resolution. We didn't go through the process of nitpicking every $5 receipt. $10,000 was the appropriate fine. You know, the amount of expenditures is, and Mr. Commissioner Barnum, you mentioned previously that we had a consent order of $10,000, or a consent order that was only 10% of the amount raised. I don't know if this is what you're referring to, but a $10,000 fine here would indicate $100,000 was raised, and that was never an issue.
Well, that's what I'm trying to get to. So I'm trying to understand in terms of the dollars that were raised, and obviously, the commission office, the audit revealed that there were funds, that there were campaign funds, resources that were not properly reported, not properly allocated, that were converted. Have you made a determination as to the value of, how much are we talking about?
Right. At the high water mark, when we couldn't really figure out what was what, it was 19,000. It's much lower than that now.
Okay.
I don't think the administration of a just outcome is worth, and I think Mr. Chalmers agrees, it's not worth fighting over whether it's 3,000 or 4,100 when we agree that the large chunk comes from using the public agency. And we can agree in general that this is an appropriate fine.
And I'm trying to get to the point where there is some consistency in logic in terms of fines that we levy. And I get earlier you suggested that you're not going to look at a first-term council person the same as you might look at someone who's running for perhaps a higher office. I will note that this was the campaign to re-elect Neil Warren. So I don't know how many, Mr. Chalmers, how many times has Sheriff Warren been elected?
Commissioner, I'm not sure. I want to say 3 or 4, but I would say with respect to that point, to the extent that you're starting to use the height of the office as a basis for determining the nature of the penalty, that's just started with this meeting. I'm not sure it would be appropriate to apply that factor to previous conduct.
Well, I agree with you, Mr. Chalmers. I don't think it's appropriate to apply the height of the office either. That was a standard that Mr. Amati suggested, and I'm trying to make sure that we have some consistency in how, if that is the standard we're going to apply, which I don't believe is the standard we should apply, or how many times someone has run, given that this was a committee to re-elect Neil Warren, should we be applying a stricter standard, or should we be levying higher penalties or more significant fines because this candidate has run before, or because they're running for a higher office, or because they've raised more money? My point is one that we need to be consistent. There needs to be rational logic applied to each case, understanding that it is going to be on a case-by-case basis, but we need to have some standards as to how we apply fines based upon violations. And that's what I'm trying to get at here.
Well, I'll respond briefly because I think I see where this vote is going. I would suggest that there has been consistency, there has been logic. Comparing a $250,000 super PAC to a county sheriff who is looking at a few $1,000s that were misappropriated and using county resources, I think comparing the two is apples to oranges. I think there has been logic and consistency applied, and I stand by this figure. And I would again move or ask the commission to move to accept it.
And my point, Mr. Chairman, is that the next executive secretary that we have might have a different set of apples and oranges that she or he might want to apply. That's my point. And we can't apply a standard based upon the judgment of a specific executive secretary when that person comes in and out of this position.
Thank you, Commissioner Barnum. And I appreciate, all of these are important considerations, and there's a lot at play, and I appreciate Commissioner Barnum's considerations, and I appreciate the staff's hard work, because I know it is hard work in getting all this done. Any other questions for Mr. Chalmers? Okay, hearing none, I want to say I appreciate both the commission staff with Mr. Amati and the other individuals that worked on this case. And I appreciate you, Mr. Chalmers, and I appreciate Sheriff Warren working together to reach a resolution here. I also want to take note that you guys did request the commission staff to go in and help with training. I want to highlight that point because I think it's important. At the end of the day, the commission and the commissioners are not here to catch anyone with their pants down, so to speak. We just want everyone to comply with the rules. So we appreciate you guys prospectively addressing the issue, and hopefully we won't have to see you again So I think that's a good point that just needs to be highlighted. And so with that, I will move to accept the consent order as proposed in case number 2019-0024 PC in the matter of Neil Warren. Okay, we've got a motion and a second by Commissioner Cranville. Any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed?
Nay.
Okay, it carries 4-1 with Commissioner Barnum, the sole nay. Okay, up next, we've got, and we're gonna do this one, and Ms. Browder, and then I'm gonna take a quick recess after this one. But I'm gonna call the case 20-0001-C in the matter of Gregory Allen, and is it Waycaser or?
Waycaser.
Waycaser, thank you. So whenever you're ready, Ms. Browder.
Thank you, Mr. Chairman. Good morning, Commissioners. I am here on the matter of Gregory Allen Waycaser, 20-0001-C. This matter comes before the Commission on a third-party complaint that alleged that Mr. Waycaser violated the Act and that he failed to, or that he committed some errors and omitted information in his personal financial disclosure statement filings for the years of 2017, 18, and 19. We propose that this matter be resolved by a compliance order, primarily because Mr. Waycaser has complied with the request of Commission staff. He, once alerted to the errors in his filings, reviewed those filings, reviewed the complaint, and contacted Commission staff to make amends. He also apologized and acknowledged the mistake that he made. The errors included, he omitted information in his initial filing that was actually a personal financial disclosure statement that was not required. He noted that he owned a business and that he and his wife owned real estate, and in subsequent filings, he noted that he was not a fiduciary and that they did not own any real property. In each of those filings, he did note that he was self-employed, and so a conflict is apparent in the filings because he noted himself as not being a fiduciary, but also being a business owner and or self-employed, and then also having filed a initial filing in 2017 showing that he owned property, but then in the subsequent filings did not include their property ownership. It was also noted that the 2018 filings, the errors in omitting information seemed to have carried over into 2019. And so I think, and Mr. Waycaser agreed that that was just basically them using the same information and carrying it forward. But again, after Mr. Waycaser was alerted to the issue, he made the corrections. An additional mistake that was made in his filings that were required is that in 2018 and 2019, Mr. Waycaser noted that the year covered was the same year that was the year of the filing, as opposed to the preceding year. And so that error was also corrected in his filings. Because Mr. Waycaser responded with urgency and immediately, and also acknowledged his error and apologized to the staff, agreed with Mr. Waycaser to not impose any type of financial penalty. And so this compliance order is acknowledging the errors that were made and the respondent agreeing that he will make no further error in future filings. And we would ask that the Commission agree to this consent order, or this compliance order.
Good, and thank you, Ms. Browder. I like to see the mask. You've now got more masks than you can. Is anyone here on behalf of Mr. Waycaser?
No, Mr. Waycaser is not here, but I told him he didn't have to come, but he could come if he wanted to. He actually volunteered to drive up to my office the same day that I spoke with him because he took the matter so seriously and wanted no issues with the Commission. And that's so that's the only reason why he's not here.
That's great, thank you. And Commissioner Cranville?
I just had a quick question about perhaps how this occurred. And staff is probably going to correct me if I'm wrong on this, but the fields in the personal financial disclosure statements, I mean, they repopulate themselves from year to year, right? I mean, so would he have had to actually change it to get it, different from one year to the next?
Well, I can't speak to how Mr. Waycaster completed the form.
So,
hold on. So Commissioner Thompson?
Yeah, so this is a local individual, so they file locally, they wouldn't be using our e-filing system, so, and they may not have a return filing system wherever they're from.
That's okay.
And I didn't highlight that. Mr. Waycaster is a council member in Grantville. He was a first-time candidate in 2017, which is when the first filing was filed. Although that 2017 filing wasn't required, but it's just covered because, you have to be accurate in what you file with the commission. So that's why that's the issue. But he is a local filer.
Okay. Any other comments? All right, well, hearing none, I will move that we accept the proposed compliance order, right? Compliance order in case number 20-0001-C in the matter of Gregory Allen Waycaster.
Second.
Got a motion, we got a second by Commissioner Watts. Any discussion? Hearing none, I will call the question. All in favor, say aye. Aye. All opposed? All right, motion carries, and I will make a motion that we take a 5-minute recess. If I can get a second. Second. And all in favor, say aye. Aye. Okay, good deal. All right, we will re-adjourn, and the next matter on the agenda, which I will call to order, is 2009-0012 in the matter of Michael Julian Bond. And who is handling that on behalf of the commission? Okay, Mr. Lane. And Mr. Lane, are you gonna do by the podium? And Ms. Little, can you hear us okay? I just want to make sure you can hear Mr. Lane and everything he says, and we'll do a mic check in 1 second.
Okay, yes, I can hear right now. I just want to make sure my client is there as well.
Mr. Vaughn is here.
Okay, great.
Okay, I'm now going to get Ms. Little, Mr. Lane to introduce himself, and then you tell me if you can hear him.
Good afternoon, Commissioners. Robert Lane on behalf of the Commission.
Could you hear that, Ms. Little?
Yes, I can. And this is Jennifer Little on behalf of Mr. Bond.
Okay, very good. Mr. Lane, please go ahead.
Commissioners, this is an extraordinary motion for reconsideration that was filed by Ms. Little on behalf of Mr. Bond, so it is the respondent's motion. So I believe that the Commission feels appropriate, it's their burden of proof, so I'll turn it over to her.
I agree. Ms. Little, proceed.
I'm sorry, I'm having trouble. Proceed, is that what you said?
Yeah, Mr. Lane said that it's your motion, and so he proposed that you go first. So whenever you're ready, we're ready.
All right, great, thank you. First, briefly, I just want to sort of go through a couple of small technical things very briefly that I came across because I do think they will factor into your analysis, or I hope they will today. As you are aware, there was a complaint in 2009, October of 2009, and my client responded to that complaint, negotiated a resolution, and in fact signed a consent order in that matter. And that is, in fact, the matter that we're here on now, which is why the 2009 case number. But there was a consent order, signed and agreed upon many years ago. For whatever reason, that didn't get approved formally, and somehow just went dormant and was sort of lost in the system. The following news story in 2014, my client reached out to the commission and to check the status of this case, and at that time the commission reactivated this 2009 case and conducted a review of records from 2009 through 2015. My client at the time explained, I am coming to you, I have a lot of health issues, I know that there are some errors and mistakes that I've made, and I want to sort of make this right. And so through that process, he provided documents, he worked with staff, he did what he could to assist in the investigation. And I want to point out that my client has always agree that he did a bad job with record keeping. He failed to report certain things, he failed to get reports in on time, and he definitely made several mistakes, and he's never denied that. As I'll go into in a few minutes, it was an extremely difficult time for him, and he had certain health conditions that made filing these reports particularly difficult. And he had always done his reporting on his own until it really became quite difficult for him to do so when he hired someone who also did, not a great job with the reports and had some issues as well. But despite all of that, and despite someone else actually being responsible for the filing of some of these, he knows that it was ultimately on his shoulders, and he took responsibility for his mistakes and did not fight the case. He, in fact, tried to reach a settlement and did reach a settlement with you guys, despite the fact that he actually had some fairly reasonable explanations for some of these violations, in addition to some technical defenses as well. And so just very, very briefly, in response to that first consent order way back when, he was required to take some classes, and he did so. And during those classes, one of the things that he was explained was that anything that was related to campaign expenses could be taken from campaign funds. And so that is why you would see some of the violations related to sort of car, gas, insurance, and a couple of phone lines that he used for robocalls at his house. But later it was determined that those were, improper by the commission, and so he didn't sort of fight that out or try to make excuses, but just to give you an example, that was one of the issues. Another issue or mistake that he made was he filed, some of these violations are related to check that was filed when it was deposited versus when it was actually received, and that was a mistake on his part. In addition, I think when I went back to review it and just looking at the statute, I think some of the violations are barred due to sort of a timing issue because the case went dormant for so long, and there is a 5-year limitation on how these actions can be brought, and also sort of some of the double dipping provisions might knock out a couple of these violations. So by and large, I just wanted to sort of point out the fact that there were things that he could have argued. There were some defenses and explanations, but he didn't do so. He said, look, I made some significant errors here. I know I'm responsible for it, and I want to get this right. And he took ownership and tried to make it right with the commission, and had these open discussions and negotiations with your staff attorney. Now, something that was a little bit troubling to me, and looking back at some of the correspondence with the staff attorney at the time, no one that's there now, but was, he was told in an email that he had to sign the consent order prior to the next meeting, or it would be turned over to the AG for prosecution. Now that just got funny with me because of the ethics rule that says the lawyer cannot sort of utilize the threat of criminal prosecution in order to obtain a civil settlement. I wanted to bring that to your attention because I know that my client did feel pressure. He was, telling us then he had no ability to pay this. He doesn't have any assets, he doesn't have any money, and was saying, I cannot make this big balloon payment. I want to work with you guys. I agree I made these mistakes, but I can't do it. And he reported to me early on that he felt significant pressure, and this sort of jumped out at me as something that I thought I might bring to your attention. And while we obviously appreciate everything that this commission is doing and the consistency that we have now, I think it's important to acknowledge that there were prior situations of mismanagement and significant changes in leadership that have taken place over the years. And that did create some confusion at the time. Ethics laws have changed, forms have changed, where and how you report has changed. And so there have been just some significant shifts over the past, many years actually, that sort of, I think, contributed to some of this confusion. Another point, very quickly, that I wanted you to know about some of the prior discussions, because I know many of you were not part of the prior hearing where this amount was ratified. But some of the reasons that were cited for, at the time, what everyone on the commission agreed was a highly unusual payment structure, meaning this $1, $5, and then $39,000 balloon payment. Everyone sort of agreed it was an unusual structure, and some of the reasons that were cited specifically for that balloon payment, and I quote, it was that the balloon payment, rather than smaller parts, would be a clearer case, meaning for the AG to prosecute. And the staff attorney mentioned that there was a backlog of cases sitting, waiting to sort of be prosecuted and collected upon, and that it would be easier and more likely to sort of move forward via the AG for collections at the time period between when the order was signed and when he was when it was clear that he was going to be unable to pay was shorter in length. And again, at that time, everyone there that day knew my client had no money, no assets. When he was sort of negotiating with the commission staff, he was telling them, I just can't make the payment, I can't do this fine amount, because he worked with me with a lesser fine. And they at that time said, well, send us all of your tax information, all of your filings, everything that you have. And so in response, during that December 2016 meeting, and I quote, my client demonstrated an extraordinary lack of assets. And so everyone knew at the time he really had nothing other than sort of the salary that he makes, with the city. And so and yet, the balloon payment of essentially what was a 1-year salary at the time was sort of assessed upon him. Now, during that same meeting, I wanted to also finally, this is my last point, to point out just one of the things that stood out to me. The commission was told, look, it's your job today to determine whether you think this is an appropriate amount in terms of the assessment against Mr. Bond. And one of the questions that was asked with regard to whether or not this is an appropriate amount was, how does this compare to the other case that we had on the docket that day? So without going into great detail, my client's case was compared to that case of the state representative who was on the docket. And my concern here is just, I want you to know that some of the numbers and information that was provided to the commission at that time were off. I'm sure it was just a mistake, not being able to go back and check exact figures, but the numbers provided were significantly skewed from what was in fact sort of the numbers in those cases. And again, I'm not going to bore you with the specifics, but my client was fined about 6 times as much as the other person, even though the monetary amount and the number of violations was anywhere from 2 to 3 times as much. And in some cases, it was on par. So for instance, for campaign donations that had failed to be disclosed, it was basically very consistent. Yeah, my client was 6 times as much. So I just wanted you to sort of be aware that the very basis of this fine, in some ways, was predicated on some information that was incorrect. But, to move past all of that, obviously we're not here to sort of relitigate the case, and my client has always, admitted and taken responsibility for his mistakes. Really what we're here today on is a hardship request because statutorily, as you are aware, the commission may waive or suspend any fee if it creates an undue hardship on the individual, and I would submit to you that this is in fact one of those cases. So I want to speak briefly about my client himself and then also his ability to pay. Over the time period when these violations occurred, Mr. Bond was losing his eyesight. Now, I've never dealt with something like this, but I can only imagine how difficult it must be. But he reports that the loss of his eyesight caused him to be depressed, extremely stressed out, and feeling very overwhelmed with the new challenges he was facing. And I can imagine how he must have felt, but he was extremely embarrassed at the time. And he recognizes now that he should have reached out for help much sooner and sort of been honest and open and transparent with some of his issues. But he was trying to sort of keep that from everyone. And in fact, he told me, most of us even, close confidence didn't know about sort of what was going on. But these issues resulted in sloppy, incorrect, and incomplete reporting, a lot of times due to his physical limitations and his failure to keep accurate records. In 2011, he actually learned the full extent of his eye condition and that he was in fact going blind. It was at that time he had vitrectomy surgery, which was designed to improve his vision, but it had the opposite effect and actually made it worse. It was that event which began Mr. Bond, using his own words, on a path to severe depression and denial. But I do want to stop for a minute and just point out here that he did bring this to the commission. And at that time he told staff he was extremely depressed. He explained how it had been affecting his reporting, and he was trying to make it right. And during these sort of negotiations and the back and forth, his vision was in fact worsening even at that time, and he was undergoing injection and laser therapy at that time. And as he described it to me, he was literally walking around watching his vision deteriorate. He was aware at the time of these discussions, that a lot of this stuff existed in terms of the explanations and defenses, but again, chose to take ownership and not fight it. And so for me, looking back at this, it really looks like that during all of these events, the entire, history of all of this, really from 2009 until, in some ways even now, but the commission was, or until, the past few years, the commission was experiencing several changes in leadership and staff, and that contributed to the mishandling of certain aspects of this case. And my client was going through the loss of his eyesight and eventually the loss of his father, which contributed to the mishandling of his report. So it seems like we had a perfect storm for both the commission as well as my client during this time, and I don't think that helped anyone. Turning to his ability to pay briefly, prior to this meeting with the commission staff attorney at the time, he had asked, I just want to mention this as well, if he needed an attorney. And he was told no at the time, and he felt like, look, since I'm going and reporting this and working this out with them, I'm not going to bother with an attorney. And so he did all of this, even attending a meeting alone without an attorney. And he did so, and explaining the whole time that he just simply couldn't afford any of this stuff. My client is visually impaired, he no longer drives, and is in therapy for his depression, and just simply cannot pay sort of this balloon payment. I want to briefly, and you might want to grab your pens, I want to briefly go through his monthly expenses, income, and liability. So monthly income for him, take-home pay, is $27.51. Well, make it $27.52. That's rounded up. His rent, where he has lived for many years, is $12.82. He has a loan for that has a payment of $256 a month. He has another loan with a payment of $325 a month, and another loan with a payment of $296 a month. His Georgia Power bill on average is $100 a month. His AT&T wireless bill is $75 a month. And he estimates that he spends about $200 on groceries per month. And I have proof of all of this, guys, so I can send you via an email the loan documents, his rent, all of that stuff. So that leaves him $216 roughly a month in sort of, health-related expenses, co-pays, everything else that he has to do outside of that $200 in groceries. And I do want to point out that one of those loans is for the first balloon payment. So he pays it $1,000 the first year. The second year he was required to pay $5,000, and he had to take out a loan for that $5,000. So one of those monthly payments is in fact for that $5,000. And so last year, when he was due to pay the $39,000 balloon payment, he came to the commission and the new staff that was there and said, here's what's going on, I can't pay this, can we restructure? And that's how we ended up here today. We are really here today sort of asking for, this to be, for a hardship waiver based upon the statutory authority that you have. I wanted to point out just a few things very quickly. This fine is the largest in history for this commission, and it is, in my opinion, higher than it should be. It's not commensurate with the conduct that took place, and it's a gross deviation from anything that he can afford. And briefly, I do want to just mention that in doing a little bit of research, pursuant to obviously the U.S. Constitution and the Constitution of Georgia, the 8th Amendment prohibits excessive fines. This is applied to civil cases and Hudson versus the U.S. 522 U.S. 93, and in U.S. versus United Mine Workers 330 U.S. 258, the U.S. Supreme Court specifically said when calculating fines, the court must consider the defendant's financial resources and the burden of the fine on that person. And in a very recent U.S. Supreme Court decision in 2019, the U.S. Supreme Court went back and sort of revisited this 8th Amendment issue and said that yes, this does apply to states. And they went into great detail, sort of extrapolating the history of this prohibition against excessive fines. And Justice Ginsburg wrote that it was essentially a constant shield through Anglo-American history for good reason. Such fines undermine other liberties. They can be used to retaliate against or chill the speech of political enemies. They can also be employed not in service of penal purposes, but as a source of revenue. It was said later on that they can have a disproportionate impact on the less advantaged, and for that reason can be used for improper purposes. And so the report went in just 2019 and said, this is an important issue, and we do have the right to look at whether or not fines are excessive, especially when the fine is going to be due and paid to the state government, that it's appropriate to sort of to look at the excessiveness or reasonableness of these fines. And I bring that up only because I want you to be aware that the financial resources of my client and sort of his ability to pay, in addition to just your sort of statutory authority to make the decision to waive or suspend this, in addition has the protections of that constitutional shield there, but it can't be excessive. And in this situation, when you're talking about someone who has those sorts of bills and can't come up with a $39,000 payment, does not have an asset to sell, you're really talking about forcing someone into bankruptcy. And that sort of situation, in my opinion, would be considered an excessive fine. And also, the court has said at different times that you also can look at the conduct itself, and it talks at different points about misdemeanors versus felonies, and the harm that is caused to the victim, or whether it's the victim or the public at large. And I recognize that these were significant violations, and that it was a very serious situation, and there were a significant number of them. But I would just ask that you consider, in light of all of that, that they were at most misdemeanor offenses. They were not prosecuted, and my client did self-report. He did come to you guys and admit that, and a lot of it was based upon sort of these extenuating circumstances with the loss of his eyesight. And so, for those reasons, I would just ask you to sort of consider that. We have a man here that doesn't have any assets. He's got $200 a month left over for all of his other, sort of expenses. And we are making this hardship request to the commission, and I beg you to consider everything I've presented, the technical issues, the defenses that were available at the time, the fact that my client self-reported and brought this to the commission, the fact that he didn't fight, that he provided documents, he was transparent about his mistakes, but also the personal nature of the reason for them. It wasn't easy for him to sort of come forward and say these things. He stands here before you today providing extremely personal information, not only about his health and the deterioration of his eyesight, but also about his emotional state and his personal finances. I mean, this is something that is very private, and he's here giving you all of that information, asking for your consideration. And I'd ask that you consider the constitutional protections that he's afforded and amend the payment structure to something that he can manage. And as a good faith gesture to the commission, he stands here today ready to sign over his stimulus check to you. And we just ask that you consider all of those things and work with us to determine what is an appropriate amount, not only overall for the fine, but per month that he can pay. Thank you.
Okay, Ms. Little, and thank you for that good presentation. Two quick questions. How much does Mr. Bond currently owe the commission?
I'm sorry, I couldn't hear you.
How much does Mr. Bond currently owe the commission? Could you hear me?
Yes, now I can hear you. So the 1,000 initial payment was paid, the 5,000 second payment was paid, and it's the $39,000 balloon payment that he came and said he's unable to make. And so it's a total of $39,000 right now.
Okay. And for you and or your client's opinion, what would you regard as reasonable?
In terms of a monthly payment, somewhere in the neighborhood of $100 to $200. I mean, again, that would strap him with absolutely zero money to pay for, like I said, co-pays. I don't even know how he's going to manage that, quite frankly, but that is what he just told me when I pressed him in terms of what can you come up with. But that is where he's at. And he's tapped out in terms of loans. Again, I can show you the loan documents.
Okay, and that's good.
The number of loans that he can take
we
out.
got that.
So,
Ms. Little, we're good. So we're going to hear from Mr. Lane, and the other commissioners may have some other questions. I just wanted to get those two first.
okay.
Good afternoon, Commissioners.
And hold on one second. Ms. Little, I want to make sure you can hear Mr. Lane. Go ahead, Mr. Lane.
I can.
Okay.
Commissioners, just by way of a little bit of background to help everyone understand the procedure of this case, because I think only two of our current commissioners were on the commission when it came before the commission in December of 2016. Three of our commissioners are newer than that. This case did begin in 2009. In 2010, roughly, the commission staff at that time did reach an agreement with Mr. Bond for violations of the law that were alleged in 2009. At that time, partial payments were made, but for whatever reason, and after a certain executive secretary found greener pastures to go to, there was some turmoil in leadership, I'll put it that way. So the consent order was never adopted by the commission. The case remained open. In 2014, when new staff came on board, the backlog of about 260 cases was gone through when we noticed that Mr. Bond's case was still open and active. The problem for Mr. Bond is that we did not sue him for additional violations that occurred in 2009. Ms. Little would have been correct that the statute of limitations would have prevented any charges from 2009 within the 5-year statute because Mr. Bond holds a 4-year office. He received a notice of new allegations in 2016, which added allegations that covered calendar years 2011 through 2016. That is what the commission had before it in June of 2016 when it found reasonable grounds to believe that a violation of the Campaign Finance Act had occurred. So when Ms. Little said that there was correspondence between Ms. Wetzel, who was the primary attorney at the time for this case, and Mr. Bond about threats of sending it to the Attorney General's office, that's normal standard protocol once probable cause has been found by the commission. You have a limited window of time in which you can consent with staff to resolve your case, and we'll bring it back to you. But if you don't consent, then we refer to the Attorney General's office for further prosecution. It matters not to us whether you consent or not. If you want to have your hearing in front of the Office of State Administrative Hearings, we welcome it. Mr. Bond chose, and I would submit for electioneering reasons, to come back before the commission in December of 2016 and enter into a consent order. Because Mr. Bond ran for re-election in 2017. So about 11 months after his consent order, he stood for re-election. Now, what the commission heard at the time was that the parties basically agreed as to what the violations were that Mr. Bond committed. They just, sorry.
Mr. Bond represented by counsel at that point?
No, sir, I don't believe Mr. Bond was represented by counsel at any time. Now, he might be able to correct me if I'm wrong on that one, but to my knowledge, no. I believe Ms. Little was the first counsel he has retained.
That's correct.
Okay. And I do have sympathy for Ms. Little going through old case files to see exactly what happened in the similar vote. What the parties couldn't agree on was the fine structure and the amount. Commission staff initially wanted a $58,000 fine. Mr. Bond gave a very similar discussion as to his health issues that his attorney has given today, that he was suffering from vision loss, depression. The commission lowered the fine amount to $45,000. And then there was an ensuing discussion between Mr. Bond and the commission as a whole as to that payment structure. And that's how the balloon payment came about. Staff had no real, for lack of a better term, dog in that fight. Mr. Bond consented to the balloon payment. He said $1,000, $5,000, and $39,000 remaining to get to the $45,000. It is true at the time he said, I don't know how I'm going to make that. But he would work on it. And in response to the continued discussion that health challenges making it impossible to pay, that this was the excuse for violations, the then chair, who was Lawton Jordan, stated rather unequivocally that Mr. Bond should seriously consider resigning. That if he's encountering...
Sorry, but it broke up really bad. I'm so
I'm
sorry to interrupt you. Could you
No problem.
repeat that?
Sure. At the time of the commission hearing, once the payment plan was agreed to, the then chairman, when the commission was adopting the consent order, that being Lawton Jordan, made a very strong statement from the chair in which he encouraged Mr. Bond to seriously consider resigning if he was encountering such health challenges that he could no longer properly account for or report his campaign finance issues. That if he couldn't manage that, then he had no business holding elected office.
And it's breaking up really bad, and I can't hear anything.
Okay, sure. Where did I cut out on you? So maybe I don't reply on the same ground. I'm hoping I didn't break it.
Ms. Little, can you hear? Can you hear Ms. Little?
No, I'm so sorry, guys. It cut off after he said the $58,000. I'm comfortable continuing going, but if you could just repeat a little bit very quickly what you said.
And where's the mic? Where's the mic that mic connects directly to? That's the mic. Okay.
It's not the mic. It's the internet there.
Okay.
The internet's not.
Go ahead.
In recapping, when the commission adopted its fines, the commission staff wanted $58,000 for total fines. The commission cut the fine to $45,000. At the time when the commission adopted its order, the then chairman of the commission, Lawton Jordan, issued a statement from the chair in which he encouraged Mr. Bond, if he was encountering the same troubles he's claiming of today, that he could not comply with the Campaign Finance Act because of his health issues, he should seriously consider resigning his position. And I feel for Ms. Little in her position in trying to characterize the violations Mr. Bond had. I want the commission to know that there were three important parts of Mr. Bond's consent order. The first, of course, was the payment of the fine for $45,000. The second was that Mr. Bond was to attend a number of training sessions by the commission, and that he would learn how to properly account and manage his campaign finances. The third one, which would probably, in my opinion, be the second most important, was that Mr. Bond was placed on a 3-year probationary period in which he was to provide his campaign finance records to the commission so that we could ensure that he was properly accounting for his funds and not converting assets. If Mr. Bond at any point in that 3-year period failed to provide his campaign finance bank records to the commission reserved the right to refer his case for criminal prosecution for misappropriation of funds. So that's one of the benefits Mr. Bond got in his consent order, was that the commission withheld the referral of criminal prosecution for his violations. Now, the violations that Mr. Bond consented to in 2016 was that he failed to disclose $26,670 in contributions. That would be in 2009. And that was a $6,000 civil penalty. And my understanding is that is what was agreed to in 2009 before Ms. Wetzel came on the commission. So whoever prior staff negotiated that in 2010 would handle that. So we didn't change those violations. He late filed or non-filed campaign contribution disclosure reports a total of 9 times between the years 2010 and 2013. That was a $1,300 civil penalty, which comes out to $144 per report. And sorry, for the $26,000 disclosure, non-disclosure, it was a 22% fine if you're keeping track of it. For the late filed personal financial disclosure statements, he either late filed or failed to file personal financial disclosure statements for calendar years 2010 through 2013, which resulted in a $700 civil penalty or $233 per report. And then there was the allegation that funds had been converted, and the total civil penalty for that was $18,500. For the converted funds, the allegations, which were stipulated to by the parties, was that $1,909 was spent by Mr. Bond on his Georgia Power bill. $2,283 was paid to his AT&T provider. $1,534 to Safe Auto for his car insurance. And $400 Mr. Bond used to purchase a CPAP machine, which comes out to a total conversion of $6,126. So you have the $18,500 fine there. The second one was for a failure to disclose contributions, and Ms. Wetzel at the time did play a little loose with how she characterized this, and that was part of the agreement between her and Mr. Bond. There was $34,510 that was made out to cash in various checks. That's one reason why the presentation that the commission received was 53 pages long. It contained all of the checks made out to cash. If you look very closely at the checks made out to cash, the same person, or at least the same 2 people, cashed them because it had the same driver's license number and the same other information banks require you to put on the front of the check when you cash them. So instead of us going down the rabbit hole to see if Mr. Bond had converted those funds, the commission staff asserted that he did convert them. Mr. Bond said he didn't, so we chose the lesser of 2 paths and said he failed to disclose, which he did, his expenditures of cash to the commission, resulting in an $18,500 fine for that as well. That's how you get to the total fine figure of $45,000. And the number structure changed a little bit because, as you remember, the original fine we wanted was $58,000. So we kind of gave certain fines haircuts to get it down to $45,000 and to keep it within the schedule of fines that the commission adopted in 2014. So I know there has been discussion that executive secretaries change on a whim what the actual fine structures are. It's important for this commission to know.
1 second.
Sure.
I just wanted to go back real quick.
Yes, sir.
Remind me, how do we get the payment structure of the what did you say, the 1, the 5, and the 39?
The 1, the 5, and the 39 was a discussion between members of the commission and Mr. Bond. Basically, at that point, the members of the commission and Mr. Bond began negotiating the payment structure for how the payment would be made.
During a commission hearing?
Correct, sir, on December 8th, 2016. Thank you, Mr. Chairman. So those are the fines, and that's how you get to the total amount. I'm sorry, Ms. Little, can you not hear? And Ms. Little is correct that the commission then asked for Mr. Bond to turn over his tax record so we could see.
Break it up again.
I'm sorry. Maybe if I knew.
Break it up again, sorry.
Is this better? Can you hear me now?
this up again right after he said, so that's how we got to the fines.
Okay. Okay, can you hear me now, Ms. Little?
Yeah, I can hear you, it's just breaking up.
Okay. Try
We're
this
good
and
to
see if
go.
it works better. Okay. Sorry, where I had broken was that I know there has been a discussion that there's not been consistency in the fine structure at the commission. Now, I can't speak as to what happened before 2014 because I was not here before 2014. However, upon my arrival in 2014 with Ms. Wetzel, the then commission chair, Hillary Stringfellow, wanted consistency, and she had the majority of her commission at the time agreeing with the desire for consistency. Because I think everyone agrees that there was a period of time where there was no consistency. Now, in 2014, the commission adopted, after a presentation, a fine structure that would guide commission staff as they came up with fines in an attempt to keep cases on a relatively similar plane. We wanted to make sure everyone was in the same ballpark, although you might be in different parts of the ballpark, depending on the level of office you were running for, the complexity of your campaign, and the amount of money you were taking away. One thing that was discussed with the commissioners at that time before they adopted the policy was a differential structure based on the complexity of the campaign. We discussed with the commissioners then that if you're running for governor, you have a multi-million-dollar campaign, you have the ability to hire good compliance staff, and you should be punished more severely than the person running for the Board of Education who's taking $2,000. And also we argued that not only should you be punished more severely, the chances of you having similar violations that would warrant a harsher punishment is very rare. There's not a lot of hotly contested Board of Education seats. But the governor's office, I think, as everyone can clearly say after last election cycle with $100 million spent, is very contested. And a lot of money flows through them. So that's just in reference to the argument about disparity. Now, I'm not entirely sure which case Ms. Little was referring to as far as the representative where they had similar transactions. From what I have reviewed and what I recall, there was no one on that calendar besides Mr. Bond who had tens of thousands of dollars that had either been failed to disclose or misappropriated. I could be wrong. I'll be honest, I don't recall every case that I didn't personally handle. But if she has the name, I'm happy to look it up and I can address it in more detail. Now, as far as we discussed the three terms that Mr. Bond got in his consent order that were his benefits. In the records that I have reviewed, it does not appear that Mr. Bond has turned over his campaign bank records since the consent order. So he's in breach of the agreement pursuant to the third part of the agreement where he has to turn over those reports. Now, in turning to the law, Ms. Little is correct about the 8th Amendment, but I submit to the Commission that the fine imposed upon Mr. Bond was well thought out and is appropriate given the level of violations that he had done. If we had referred his case for criminal prosecution, he would not be facing misdemeanor charges. He would, for campaign finance violations, face misdemeanors. But conversion and theft of funds from your campaign would actually be a felony based on the amount of money we would have alleged had been converted. So that's just a simple fact and issue. As far as the law, I'm afraid, and I understand what Mr. Bond and his counsel wish to do, but I'm afraid there's no provision within our code that allows the Commission to set aside and reconsider its order. And this always gets kind of lost, so I'm going to refile the ground again. When you have cases before the Commission, you have distinct phases where certain rules apply. Prior to a preliminary hearing where you find reasonable grounds to believe a violation occurred, Commission rules apply. Those are the consolidated rules and regulations of the Commission found in Chapter 189. After the Commission finds reasonable grounds to believe a violation has occurred, the Administrative Procedure Act then kicks in and then controls. And there's actually an argument to make that it applies under your consolidated rules and regs, which are given a little bit more leeway to play around with the Administrative Procedure Act before you find reasonable grounds. From reasonable grounds to your final order, the Administrative Procedure Act still applies. If Mr. Bond had chosen to appeal the decision, which he had 30 days to do after this Commission issued its final order, the Administrative Procedure Act still applies to the Superior Court sitting as an appellate court. After if you were to appeal after the Superior Court, then the Appellate Practice Act would apply to the Court of Appeal, the Supreme Court thereafter. And that's usually found in Code Section 50-13-19. Additionally, the Court of Appeals has discussed in Shefflin and Company versus Strickland, Supreme Court, 253 Georgia 385, it's a 1984 case. In Georgia Power Company and Federated Department Stores versus the Georgia Public Service Commission, 278 Georgia Ave 239, 2006. Those courts have stated unequivocally that the Civil Practice Act does not apply in the regulatory administrative setting. So you do not have the powers contained in 91160, which would be the motion to set aside and the motion for extraordinary reconsideration. Now, I know the majority of our commission is all civil leaders, so I'm not going to belabor the point on the Civil Practice Act, since I've already argued that it doesn't apply. I don't need to give you the history lesson on it. If it did apply, what would happen? But just suffice it to say, a motion to set aside has to occur within 3 years. Unfortunately for Mr. Bond, December 8th was his final order. He had his motion to set aside reconsidered December 23rd. 3 years had come and gone by that point, so he was late. So even if the Civil Practice Act would apply, he would be deprived of jurisdiction to do it anyway.
Yeah, so understanding that your argument is the Civil Practice Act doesn't apply, what do you make of what I believe is the underlying request here, which is a finding of undue hardship? So in Code Section 2156, no, well, perhaps. Yeah, but it's 2156B 14C1. Let me find it again. In imposing a penalty or late filing fee under this chapter, the Commission may waive or suspend such penalty or fee if the imposition of such penalty or fee would impose an undue hardship on the person required to pay such penalty or fee.
Yes, sir. I would argue to the Commission that code section applies when the Commission is considering the imposition of its fines and fees. Once you have imposed those fines and fees and you have issued a final order under the Administrative Procedure Act, the only course for reconsideration available to Mr. Bond is contained within the Administrative Procedure Act, which is Code Section 50-13-19, which contains no provision for a reconsideration or a set aside or a modification of the final order. Now, if the Commission, sorry,
I can't hear. Is this microphone on?
It is, but I have a choice between this one and that one.
Because I can't hear. It's not picking up.
Do we know if there's a correlation between using that mic and the company? Why, is there any explanation for why there would be?
Because I'm hooked up to your system. If he can't, I can't hear him
Yeah.
because the mic's not on, or if he's
So
in front
try
of
to just talk into the mic as you normally would. I don't know why that would cause a streaming issue.
Sure. If the Commission is
Is it just, I would just stand like you normally do.
If the Commission is desirous of modifying the terms of the payment plan, one option available to the Commission is not the reopening of the case or the modification of the order, but the Commission as a policy-setting body can issue instructions to staff on how it chooses to collect those fines. Currently, for us to collect the $39,000, we are required to send the case to the Attorney General's Office, Department of Collections, and they would then sue Mr. Bond, they would obtain a money judgment, they would then get a fine stay, and then they begin garnishing the City of Atlanta wages. The Commission can instruct staff either to send that, not send that, or provide us guidelines. And if Mr. Bond meets certain payment requirements, we are not to send it, or if he violates, we are to send it. So it keeps you from establishing a precedent, which frankly, I respectfully submit lawfully you can't do based on the Administrative Procedures Act.
Thank you. So I want to make sure I understand your argument, because you said once the Commission imposes a penalty, the Commission cannot later either modify or suspend that penalty outside of the procedures that are included in the Administrative Practice Act.
Correct, Commissioner.
Okay, so then what do we make of the term, the commission may, this is back in the same code section I was referencing a minute ago. The commission may waive or suspend such penalty. So we can waive it or suspend it. So we can suspend it, to me, means we can lift it. Waive the penalty would be at the outset, I would think, perhaps when the initial penalty was to be imposed. Suspend it is at some later time.
Generally, the way the commission is treated, suspension of penalties is referring to late fees that are incurred. The commission, by prior vote of several commissions ago, delegated the ability to waive and suspend late fees, as they are automatically applied to staff and the executive director, as long as it meets certain qualifications and guidelines set by the commission for those waivers.
But this particular paragraph is talking about a civil penalty.
Correct, and I think if the Administrative Procedure Act had a mechanism whereby you could open a final order, you would be able to use it to justify a changing of that order. Once the final order becomes a final order, there's no mechanism in the APA for the commission to reconsider it. It's not like a superior court that has the inherent power, as long as it's the same term of court, to change its order because of changing facts or circumstances, what have you. You don't have that authority. It doesn't exist.
That's not technically right because of something you just said, which is the fact that we can suspend the late fees. So you have a consent order, right? It gets approved. In there, somewhere in the consent order, it says late fees will be applied in some way, shape, or form. And then we can somehow suspend that or change it.
And I would respectfully disagree slightly with that statement, Commissioner, in the fact that late fees are automatically imposed by operation of law. The commission is not required to pass an order enforcing those late fees. That's why they automatically pop up on the website and disclose to the public, and members of every elected branch can pay their late fees without ever having to step foot in front of the commission chambers. In fact, you're going to see that in a case, Miss Gina London Pilcher is on the calendar, has that exact same issue.
Okay, but if we have, let's say, the consent order or some other order says if you are, dilatory in your payment, we're going to refer the case to the Attorney General. We have orders that say that, right?
This one particularly.
Okay, but what you said at the outset is, well, not the outset, but in the middle of your argument was, if we wanted to modify, which is to my point here, that we can, I think we have the right to either waive or suspend by law. But taking your point and your argument, if we wanted to modify that order and say, do not refer the case to the Attorney General's office, we could. But what you've said is, that's included in this order. And so technically, we're changing the order.
I was obviously inarticulate, so forgive me for that. I did not say that you could modify the order to instruct us not to do it. That the commission could, as policy, instruct staff on its prosecutorial discretion on how it proceeds forward in enforcing that order. To me, it's a distinction. Maybe it's a distinction without a difference. But you're not changing the order, you're telling us how you're prioritizing our enforcement of your orders.
So your line is that the $45,000 is a final order. It cannot be changed outside of the Administrative Procedure Act. However, the commission can ask you or direct you as a policy function to collect the $45,000 in any way we deem fit.
Or not to collect it at all.
Well, that's inherently contradictory to what you just said.
Let's hear from Ms. Little. I do think that this is an important point. Ms. Little, can you hear me okay?
I was able to hear you really well until just like 2 seconds ago, but yes, I agree with that point, obviously. I do think you have the statutory ability to do so by my reading of 21.5.6. I do think that it speaks directly in that paragraph to fees that you are assessing, and it gives you sort of a structure, examples of the amount, and in that paragraph it says you may also waive or suspend. And so I think you absolutely have the authority to manage this agreement at this point, to amend it, to restructure it. This has not been sent off into sort of the stratosphere of litigation.
So, Ms. Little,
Collections formally, and so I think this is still within the purview of your commission, and based upon my reading of that statute, I think you absolutely have the ability to waive or suspend it.
Okay, and so I want to try to narrow the issue on this. Are you in agreement with Mr. Lane that we cannot amend the consent order that's already been fully executed, that our only ability to in any way alter this existing fine amount is to instruct the commission to change how they enforce the already entered order? Are you in
No, I
agreement?
was in agreement with your position that you can amend the entire consent order at this point.
Okay, and what legal authority do you have for that?
And that paragraph of 2156, I think you were reading it correctly. I think that, as I just said, the paragraph specifically states your authority to fine, and it is discussing that specifically within that paragraph, and it does say that you can waive or suspend a penalty or fee. And so it doesn't say you may suspend automatic penalties or fees. It doesn't say you may waive, penalties prior to an agreement, but you can only suspend automatic fees. It's not specific. It says you have the ability to waive or suspend. So, in my opinion, you have that authority even after that consent agreement was entered.
Okay, Commissioner Cranville's got a question.
Yeah, Commissioner Watson and I, historically, we've agreed on certain things the way we've been able to read it out. I think I disagree with you this time, and I don't know if this is what Mr. Lane is getting at on this, but it's the beginning of the sentence that's important here to me, where it says, in imposing a penalty or late filing fee under this chapter, the commission may waive or suspend the penalty. Because it says in imposing it, that means at the time you actually enter the consent order. It's not thereafter. It is in imposing a penalty. At the time you do that, you can make a decision and say, hey, I am now going to waive or suspend a penalty or fee. And now we're way beyond that. We cannot now go back into an order that was final in December of 2016, completely reopen it and rework it at this point. I do not think that the statute provides the authority for that.
Okay, Commissioner Watts.
So the hardship I'm having with, no pun intended, wow, but the difficulty I'm having with this particular sentence is waive or suspend. And suspend to me means something's already in effect. But putting aside this particular sentence and this authority, what I heard Mr. Lane saying that I think maybe we just got crosswise on is that, is it your position that even under the Administrative Procedure Act, the commission has the authority to direct the commission staff to collect the amount imposed in any way the commission deems fit?
Correct, because the way we do a ministerial collection is not controlled as, it's like a civil. For example, the example I give, and maybe a bad example, you obtain a judgment for your client. And your client says, you know what, I've got my judgment, I don't care about collecting $1 million judgment we just got. You have the ability to say, well, we're not going to collect it. The Civil Practice Act doesn't control how you collect. The statute of limitations on money judgment controls how long you get to collect it at 7 years. So it's two totally different animals. It's apples and oranges.
And so by that logic, then the commission would be empowered to change the amount that would be collected in total.
Without opening the order and issuing a new consent order in case number 2009-0012, it's possible.
Can we or can we not?
It'd be like your client sending you an email telling you that they don't want to collect the judgment you just got. You have the ability as a commission to right now, send a message to your staff that you don't want us to take any further legal actions to collect this judgment.
Under the administrative
Essentially, we do that all the time. You know, I get contacted by clients all the time that say, I've got this judgment, can you go and collect it? Can you go and negotiate it for me? And I go to the agency and sort of negotiate a resolution based upon what is reasonable for the client to pay. And that is what we're discussing here today, and that's what we're asking for.
Yeah, I'm just trying to get the options, and the legal discussion is, I mean, I can understand a different reading than the way that I read it for 2156. But the other option is what you're saying, is that under the Administrative Procedure Act, we can modify, I'm not saying we should or shouldn't, but we can, the option is we can modify the penalty and the way in which the penalty is collected.
No, I'm not saying under the APA you can modify the order. I'm saying outside of the APA, outside of your case management structure, this body has the ability to control how its staff functions outside of the case setting. It's just like your client telling you not to collect a fine. You can tell us not to collect the fine. You can tell us to collect only 10% of the fine. Now, in addressing that point, since we've addressed the legal aspect of can you open a case file or not, I would submit to the commission there has been no change in circumstance on Mr. Bond's behalf between when you entered this order and today. In fact, the real change is that he makes $20,000 more now than he did then. So he's actually in a better financial position to pay the fine than he was when he agreed to it in 2016. So
to that point, I did have one other question, if you'd allow me, Mr. Chairman. Do you have any reason to dispute, I mean, I understand the $20,000, but just the numbers that Ms. Little read earlier about, I guess, discretionary monthly income that is left for Mr. Bond. Do you have any reason to dispute those numbers?
Commissioners, unfortunately, I'm in a legal impossible situation because, number one, we don't have the authority to subpoena personal bank records unless we can show that campaign finance funds have gone into them. And arguably, the transactions we say were converted are beyond the statute of limitations. Additionally, in an old closed case that we're arguing legally you cannot reopen, we have no grounds to issue a subpoena. So no, I'm not in a position to either challenge or affirm his assertion.
I can send you guys copies of everything right now. I have every loan document, every rent payment, everything.
All right, Commissioner Thompson, Commissioner Barnum.
I guess where I'm at is that, to a point Mr. Lane made, was that Mr. Bond came before the commission, negotiated the settlement of what he thought he would be able to do. And in my opinion, just reading the consent order, it sounds like, he's just lucky he didn't go to a criminal thing if everything that was said here today is true. I mean, I'm not really in a posture that I think we should change anything. And if he needs to appeal it, he has a process. He could go to an APA or the Attorney General's or the next step, and he can please case there.
Commissioners, I don't mean to speak out of turn. Mr. Bond wanted to make a statement. He was trying to talk to me directly, and I told him he needed to speak to his attorney or you directly, and not to go through me. So if you'd like to hear from Mr. Bond.
Well, we'll let Mr. Barnum speak.
Absolutely.
And then Mr. Bond. So Mr. Barnum, or Commissioner Barnum's got a question.
This is less of a question. Ms. Little, can you hear me?
Yes.
Okay, yeah, I think it is freezing.
I just want.
Go ahead, Ms. Little.
Okay, I'm sorry if I'm cutting someone off. No one was speaking when I started. The suggestion by Mr. Lane that the commission, in exchange for this consent agreement, agreed not to turn this over to the AG's office is absolutely incorrect. At the December 8th, 2016 meeting, and I can send you the link so that you can watch the entirety of the meeting, Mr. Ritter said on multiple occasions that he had sent this to the AG, and that he in fact had even contacted the Fed to try and get them to pick it up, but that no one was interested in the prosecution. And I can give you quotes and times on that from my notes if you give me a few minutes. But I am 100% certain that he said during that meeting, no one was interested in prosecuting, and it could not be prosecuted. So this was not a deal that we got a benefit for not, being prosecuted criminally. That was absolutely not on the table by the time we went there.
Commissioner Barnum, do you have a comment or question?
Sure, I guess I have a different take on it than Commissioner Thompson does in that, I think if we punt on this and force Mr. Bond to go through an appeals process, he's not gonna be in any better of a financial position later than he is now. And arguably would be in a worse financial position because there'll be, he'll incur legal fees and et cetera. I think it will just be kicking the can down the road or kicking it to someone else to try to solve. I don't know that I have a solution other than the one that Mr. Lane suggested that I don't love. Because if, in fact, we can't reopen the case, and I think there's a certain logic to the idea that at some point the case has to be closed, right? And I don't want to set a precedent. I'm concerned about setting a precedent that in future years, in future cases, when someone else is having hardships, that they can come and reopen a case 4, 5, 6, or however many years later, and then we'll just redo it altogether. I think we're probably in the position of taking the suggestion of the path that Mr. Lane offered, which is making a decision that we are going to collect in a way that is feasible and consistent with what we understand Mr. Bond's financial abilities might be. So that's kind of where I'm coming down, because we can't squeeze blood from a turnip. I've been trying to do a little bit of research on some of those Eighth Amendment cases that Ms. Little cited. That was a compelling argument for me in that, is there a potential Eighth Amendment violation here by imposing penalties or fine that under the circumstances, the respondent here, we know and he knows that he can't pay. That troubles me.
All right, Commissioner Thompson.
Just quickly, since I'm not an attorney, we are imposing it, but it was agreed upon by the individual. It's not like we just arbitrarily made a number up. He actually agreed. So does that argument still, and I don't know, I'm asking.
Well, and I think while there may be a consent order in place, it is the state, as a state actor, has the ability to collect that fund. And I forget who one of the founding fathers said something about, the ability to tax is, a powerful authority. So it would be the state imposing, collecting on the fine, whether or not it was agreed to.
Okay. Have you guys tried to work out an agreement on how much he can pay now?
My understanding is discussions have been made, and Mr. Bond's offer was the payment of, I want to say $1,000 if I remember correctly.
Secretary.
We're asking for him to, again, as we said today, sign over the stimulus check and renegotiate sort of a monthly payment, and that negotiation fell flat.
Okay, how much is the stimulus check?
I believe it's $1,200. Is that correct, Mr. Vaughn?
I'm afraid Mr. Bond stepped out to the restroom.
Oh, okay. It's somewhere in the neighborhood of 1,000 to 1,200.
I mean, my trouble with this is that this agreement was entered April 2017. There was a first payment of $1,000 in December 2017, a $5,000 payment in December 2018. And so Mr. Bond had an ability to situate his finances in a way to put him in a position to make a final balloon payment. And the whole basis of balloon payments are right now you're in a difficult financial situation, but we're going to give you time to position yourself 2.5 years down the line to make a final payment. The Eighth Amendment issues, I've actually researched those issues in a very similar case. It's almost impossible to prevail on an Eighth Amendment issue in this type of context. I do sympathize with Mr. Bond's situation. If people go through hard times, this is a large fine. I would love, what I would prefer to happen, because I think Commissioner Barnum's right. I mean, listen, we could say he's got to pay $1 million, but we're not going to recover a penny. So that doesn't really do us good. What I would like to happen is by saying, in my position, I don't know if the other commissioners agree, it is not in our best interest to create a precedent where a party agrees to make a payment over an extended period of time, and then at the 11th hour says, I can't make payments because of all of these reasons. Not saying Mr. Bond's reasons aren't true. I'm in no way suggesting that's not true. But that's a precedent that I just don't think that we can create. My proposal would be that within the confines of it's not going down to zero, that you guys try to work we table it to August. And I understand, I mean, listen, I was on the commission the last time Mr. Bond was here. And I remember, and Ms. Little, you weren't with council at that time, I remember similar arguments. And again, I'm not being dismissive about this, but I'm just saying any individual had 2.5 years to put themselves in a financial position to make a payment, and they don't do it. We can't just let them off the hook, because that totally worsens our appearance as a commission, and I hope you guys appreciate and understand that. However, we want to work with you guys. Yeah, sure.
Just want to, and it strikes me that, Mr. Bond, your inability to pay does not come as a surprise from what I can understand. And Ms. Little, your client's inability to pay is something that folks have known about for some period of time. And it sounds like maybe there have been some efforts to renegotiate, but it doesn't sound like those efforts to renegotiate. I mean, someone enlighten me. How long have you all been having discussions, or has there been an effort to renegotiate?
Yeah, and Secretary.
And like I said, I've been trying to get this in here.
Okay.
And then take this information for whatever it's worth, and Ms. Little and I have spoken about this. I met with Mr. Bond, and a representative I don't know that he was a lawyer, but he was some sort of representative last year in November, December, that was the end of the year. And we talked about, and I said, look, there are no promises for a number of reasons that are problematic, but I'm willing to at least have this opening dialogue. And I said, what can you pay now? $39,000 is owed. You've had 3 years. What can be paid now? And I was told something to the effect of $100 or $200. And that's a tough position to start a negotiation from relative to the amount of money owed. And I said, I'm not making promises, but if you can offer up a chunk up front, and then we can sort of ferret out the rest, I might be open to that if the commission is. But again, I was given a number that was completely in another stratosphere. And the commission can take that for whatever it is, but I've heard that question asked a few times, and I want that information out there.
Yeah, I mean, what I think I'm hearing from the chairman and Commissioner Barnum
And the other
is,
thing I was, may I speak? Is someone else speaking?
Go ahead, Ms. Little.
Okay, okay. The only thing that I was going to, I understand the frustration. You guys put in time and effort. This is an agreed upon order. I get it. I do. I guess what I would just ask you to consider is also, this is not an individual that could go out and start taking lifts with Uber or really get a second job. This is someone that has significant health issues that prevent him from operating a motor vehicle. And so, you know, I understand that yes, you know, he should have been finding ways to get this money, but he has limitations that the rest of us don't necessarily have in certain ways in terms of how much he can do, number one. Number two, he had to strap himself with a second loan or a third loan in order to pay the $5,000, which created a monthly amount, you know, of payment that sort of took up yet again the money that he could have been saving. And so, you know, to tell anyone that you know, you have to live on $200 a month is a difficult task. And so while I appreciate your frustration and the concern, you know, it's a fairly difficult situation for him to sort of try and climb out of, which is why I think, you know, it was a situation with the discussions with Mr. Lottie where, yeah, the offer was, you know, not enticing because there's just nothing there. And I will say that, you know, there were discussions, you know, I believe prior to that, that I don't have notes on or anything, but I don't believe that the first time anyone was approached was that late in the ballgame. But I just wanted to point that out for you. There was one other thing, the suggestion that I guess Mr. Lane made, that someone asked how the balloon payment seemed to be, and I believe Mr. Lane said that the commission came up with that. But when I watched the December 2016 meeting, the commission, and Jake, you may recall this, in fact, your question was, well, if he doesn't have any money, how is he going to make a $39,000 balloon payment? And so the commission was sort of questioning the payment structure, and Mr. Ritter and the staff attorney, Ms. Wetzel, were sort of suggesting why they needed that balloon payment, which is where I got the quote from earlier when it was suggested that there were a backlog of cases with the AG and that a bigger single payment like this would be an easier case to sort of prosecute later when he was unable to pay it. And so I just wanted to point that out to the commission. It had already been consented to. I want to be very clear. My client had already consented to the balloon agreement, but that was not something that the commission came up with. That was previously consented to, and in fact, there were a significant number of questions with regard to the structure on that December 8, 2016 meeting.
Yeah,
And one other thing, we were talking about the amount of the fine, and Mr. Lane mentioned the fact that my client had $34,000 in, you know, checks written to himself. And the case I was talking about, Mr. Lane, just so you know, was Representative Smith. He was also on the docket that day, and he had $19,000 in checks written to himself. $19,000. We had what your figure says is $35,000, and he got an $8,000 fine, and we got a $45,000 fine. So that's what I was saying. At worst, the sort of monetary amounts were 2 to 3 times as much, yet our fine was 6 times as much. So I just wanted to give you that information, Mr. Lane, so that you are aware. It was Representative Smith, and just to sort of give you that, you know, basis. Yes, we did have 34,000. He had 19.
Yeah, and we appreciate that, Ms. Little. And at the end of the day, Mr. Vaughn is an important litigant, but he's one of our many litigants. And so we have to make any decision, not just, particularly a decision like this, not just within the confines of this case, but in the consideration of precedent. And the precedent of this case is Mr. Vaughn agreed to a consent order, which created a payment plan where he would have 2.5 years to make payments. We are now past the final payment. and you guys have asked for an undue hardship, when similar arguments were being made back in 2016, and I remember it. Nevertheless, I think I would propose that we move to table this. You guys, which puts it on the August agenda. You guys have time to try to work out a deal and spend time really digging into, we've made progress. Mr. Bond's got 1,200 you're willing to do. And not having the commission kind of work through all those weeds for you guys. If you haven't came to a resolution in August, which I hope you have, but if you haven't, we will be willing to consider this hopefully on an expedited fashion because a lot of the arguments have already been put up. But I say that to say there's question into how legally the commission's even able to execute this law, what you're asking us to execute. Can we amend an already entered order? Do we dictate to the commission, hey, commission, only execute this already agreed order up until a certain point? That doesn't really feel right or good to me either. And I think us even doing this is operating in good faith and giving you an opportunity to do this. But I'd like for us to be able to continue to move our agenda along. And Commissioner Barham, go ahead.
And if I may add to that, I would encourage Ms. Little on behalf of your client, Secretary Amati, Mr. Lane, let's give some real consideration to what is the best use of the taxpayers' resources. Okay? Because you all, our staff, you're compensated, the time, the room, everything that we're doing here, this is all a use of taxpayer resources. And if this ultimately gets referred to the AG's office, and I believe we're talking about for criminal prosecution, am I correct?
For collections.
Collections, okay. Is that the best use of taxpayer resources? Because I would think that the AG's office wouldn't be able to collect any more than we might be able to collect. I just encourage all sides to give that some consideration.
Commissioner Watts?
Just the final thing I'll add, because I think you had the policy statement that we were talking about earlier, or discussing earlier from the commission. But I do also have a concern about precedent setting and allowing what seems to have been known on both sides, perhaps, that whether the money that was agreed to was even available. But what I will say is that we have a duty to continue to move cases along. And so whatever agreement is reached between the staff and Mr. Bond that's presented in August, I hope that it's reasonable, and I hope that it is very clear that if payment is not made according to that plan, this case is moving on. It's moving away from the Ethics Commission because it's been here for a very long time.
Mm-hmm.
Understood.
Yeah, it does go back to 2019. And Mr. Bond, I hope you and I remember you coming in person last time, and I always tell litigants I appreciate when you come in person. It shows you take it seriously, and I appreciate you coming today. And I hope that you see where we are coming from, and I hope you guys work hard to reach a resolution in August. If not, as Commissioner White said, under my chairmanship, one of my most important elements is showing that we are a commission to be taken seriously. This is a commission that historically maybe has not been taken as seriously as it otherwise should be. And under my chairmanship, there's a low likelihood I'm going to allow consent agreements that were made to not be enforced. And when the parties, and I'm not saying it's on you to win, you guys primarily, but execute in good faith to try to get it done. That way we don't have to work it out because you guys have already worked it out. So enter discussions the next month. Hopefully we don't see you guys again. If we do, we do. But with that, I will make a formal motion to table until the August of 2020 meeting, the matter of 2009-00112 and the matter of Michael Julian Bond. If I get a second. We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay.
Aye.
Good deal. The motion carries. all in favor, and I will make a motion that we move for recess to have someone.
Mr. Chair.
Oh, you're opposed? Oh, sorry about that. Sorry about that, Commissioner. I don't know if I should do that again or not. Let's do that again, just so for the record's sake. I'll call the motion. All in favor, say aye. Aye. All opposed, say nay. Okay, the motion carries 4-1 with Commissioner Thompson as the sole name. Okay.
Mr. Chair, I just want to thank the commission for your indulgence and apologize for any undue time or distress that I've caused your deliberations. My goal is to be able to pay, and that's been my goal all along. And as far as the bank records, I thought that the commission was monitoring my bank records online, but I'll make sure that that has happened. I have not gotten a $20,000 raise. The $45,000 is what I bring home after taxes. And so we will work diligently to make sure that we have something for you next time.
Well, thank you. Thank you, Mr. Vaughn.
Thank you.
All right, I'll make a motion that we move for recess for a lunch break if I get a second. All right, I'll call the question. Got a second? All in favor, say aye. Aye. All opposed?
Mr. Chairman, I would recommend that a motion be made by a commissioner to handle A through G, which are all Mr. Cusack's ADs, as one, and presumably vote on those collectively. I would recommend the same with Ms. Browder's in H through K, with the exception that number J has someone on the line to call in, so I would pull that out and handle that separately.
Let's do this. Mr. Cusack, if you can just go through an overview, because I just want it on the record that you just went through each of these in the commission, through a private of each of these quickly, just what the fraction is, why you recommended a dismissal, and then we can handle A through G all in one motion, so you can just go through them.
Okay, that's good. The first one's the matter of Robert D. Gasaway, 2018-0142. It was a third-party complaint which alleged he had a late fee of $125, which he didn't pay. So that's why we're dismissing it, because he paid the late fee just online. It's not a general late fee. There's no further violations, so that's why we're
And let me also say this: for Gasaway, he was a former client of mine, so I will recuse myself from those two matters too.
And the second one is a later complaint that came in on Mr. Gasaway. That was for a negative balance in his campaign account that was showed on a January CCR. The next filing he did brought the accountant compliance and closed out his account, so we're choosing to administratively dismiss it. There's no fine associated with technically that having a negative account, so that's why that one didn't. The next one is a matter of Chris Severs. Mr. Severs ran for sheriff in Fayette County after a 30-year law enforcement career. This came in as a commission audit of Fayette County. Mr. Severs lost to the incumbent sheriff there, and then didn't file the rest of his CCRs for that year, even though he closed out his account after he lost the election. He has since moved to South Carolina right after the election. He now plays country music up and down the coast in South Carolina. So he has no plans to come back to Georgia to run for office. He's outside of jurisdiction, so we choose to leave this one just based on we're not going to be able to get hands on him. He's not coming back to Georgia. Sounds like he's living a good life right now. The next one's 2016-0060, matter of Richard Roundtree. Mr. Roundtree is the sheriff in Richmond County. He's in a third-party complaint because of a commercial that was made for his campaign, which showed a police car in his campaign. There was a brief 1-second police car that was shown in his campaign. He's running for re-election sheriff. No sort of advocacy, anything. His challenger, who lost to him, filed this complaint against him. There wasn't a 30.2 violation, which we discussed earlier with Mr. Warren here, because no one really took part. It was just a picture of a police car. That was the crux of the complaint. So that's why that one's being administratively dismissed. There's no violation of the act. The next one is in the matter of Gerald Evans Jr. This one's 2019-0055. Mr. Evans ran for Doraville City Council in November of 2019, and it was alleged that on one of his CCDRs, it was alleged that he exceeded in-kind contribution limits. He did not. He only had one in-kind contribution of $731, which was well below $2,800. There was an issue with him showing that he was going to reimburse himself for a suit that he bought to run for office. He didn't have a suit. So he originally put that on his CCDR. He was going to reimburse through campaign funds for himself buying that suit. He called the commission and asked if he could do that and was told he couldn't do that. And so I asked for proof of these receipts being bought with his personal, he got some alterations done on there. So he actually furnished us receipts showing that he bought this in his personal capacity, or bought it with his personal credit card and had the alterations done with his personal debit card, and ended up not reimbursing himself through campaign funds. So we received proof that he actually bought those without campaign funds. So there were no further violations of the act, so that's why this went to the nomination. The next one is the matter of Tom Gray. This was a third-party complaint in which it was alleged that he exceeded maximum contribution limits, that he failed to make 2-day business reports, that he failed to properly report expenditures, and he failed to identify end recipients for payments and reimbursements to himself. He did none of those things. He did have a late fee with us. He paid the $125 late fee after we let him know that was outstanding. But from everything, his CCDRs on their face appeared to include every expenditure. He wasn't hiding anything. The end recipients for the reimbursements for him, but he bought a PO box for his campaign, which is permissible, data for his campaign, and stamps for his campaign. So these are all ordinary, necessary expenses to conduct a campaign. So there was nothing wrong there. So that's why this is being administratively dismissed. The last one I have is in the matter of Educators for Irwin. This one's a bit of an interesting one. This came in as a third-party complaint by the executive director of Pioneer Regional Service Agency, and they are an agency that helps fund schools up in Northeast Georgia. And they basically cannot participate in any sort of political advocacy, so they said, we saw this mailer, and it's from it's purported to be an endorsement from the former Stevens County Superintendent Sherry Witt, saying Chris Irwin, who was running for office against Mr. Gasaway in a previously talked about election, that she was calling him fiscally responsible. Now, what happened was the return address came back to this Pioneer Regional Service Agency, and they conducted an investigation, determined no one in their agency had sent this. And so what this ad was supposed to do is, Ms. Witten had some trouble with the finances in Stevens County, and the education system there was actually heavily in debt. And so there was some allegations that there was some mismanagement of funds, and that she ended up having to step down. So this endorsement, by saying Mr. Irwin was actually fiscally responsible in this ad, was the reverse of that. It was saying somebody who wasn't fiscally responsible is endorsing him as being fiscally responsible. So it's a pretty dirty mailer. It's pretty wild, but we tried to track down where this actually came from. And I called the sheriff up there, called every print store in the area, and it became pretty obvious that somebody was able to order these mailers online with prepaid postage and deposit them in any mailbox. So there's no way to tell where it came from. There's no way to track its origin. We thought the sheriff up there might have had an investigation into this, so we consulted with him, and he said, origin of this, and we sort of exhausted all leads. We've come to sort of the end of the road where we can't really do much else based on the evidence we have. So since we've exhausted all our leads, we're going to put our resources into investigations where we actually have some leads. So that's why this one's being administratively dismissed. We tried, but that's the last one I have.
Good, well, thank you. I will tell you that was a vicious race up there. And this is another one, I'll recuse myself from both of these. This was the election contest I had. It was Gasaway v. Irwin. It was just nasty.
Which one of the races is vicious?
It got more vicious. Each one that went by. So if someone wants to make a motion on those three, you got, and I will recuse.
I think that we've addressed this before, but this doesn't actually require a motion.
Yeah, that's true. That's right.
We're just
That's right.
It's just kind of good money.
It requires a motion to bring it
Okay, good. I think you've made that point every time.
So next time.
I don't have to recuse. All right, good. Well, Ms. Browder, we're ready whenever you are.
Thank you, Commissioner. I have 4 cases listed, but J and K are actually for the same entity. The original name was what you see for 2019-0004, and then the registration or name was amended with Secretary of State to become the name that you see in 2019-0002. So when we get down to J and K, Ms. Leak is on the phone because she wants to be heard, and so it would apply to both of those and not just J. So the first matter is 2019-0056, and that's the matter of M.D. Nasser. Mr. Nasser, at the time that the complaint was filed, was actually a council member, I believe in Doraville, and he ran for mayor. Yes, it was in Doraville, and he ran for mayor. And the complaint was a third-party complaint that alleged that Mr. Nasser received an in-kind contribution in excess of the amount allowed by the Campaign Finance Act. Mr. Nasser received 3 in-kind contributions, and the total of those were less than the $2,800 contribution that is allowed. I think the largest contribution that was an in-kind contribution was $1,323.77. And the total of those 3 were $2,073.77. And so for that reason, the staff recommended that the complaint be dismissed because there were no in-kind contributions in excess of the allowed limits by the Campaign Finance Act. The next matter is 2019-0059 in the matter of Marcelo Zapata. This is also a local election or a local official. Mr. Zapata is alleged to have violated the Campaign Finance Act by failing to file the name and address of his campaign committee's chairperson and treasurer. And he serves as a councilman in the city of Roswell. And so we recommended dismissal of this matter because Mr. Zapata, well, there was no evidence to support that Mr. Zapata actually had a campaign finance committee or a campaign committee. His declaration of intention to accept campaign contributions nor his campaign contribution disclosure reports indicated that there was a campaign committee. At no point did he file any documentation with us or locally to show that there was a campaign committee, and because of that, there was no requirement that he file the name of a treasurer or chairperson, because that just didn't exist. And so that's why that matter was recommended for dismissal.
Who filed the complaint on that one? He said he was running, but he just really wasn't running, or?
No, he was running, but he was the only he was the only person responsible for his campaign contributions. There were no third parties involved.
Okay.
So no one accepted contributions or made expenditures on his behalf, only him. Well, there was no evidence of that anyway.
Okay.
But the complaint was filed by Mr. Jerry Wood. And then the last matter, or the last 2 matters, are 2019-002 or 0002 and 2019-0004 in a matter of Imagine Greenhaven Inc. and what was Concerned Citizens for Cityhood of South DeKalb, or formerly known as. And these are 2 complaints or 1 complaint. There were actually 4 complaints that were filed by Ms. Leak. 2 of the 4 were rejected, and these 2 remain. Ms. Leak alleged that Imagine Greenhaven violated OCGA 21-5-1 through 21-5-76 with an emphasis on 21-5-30 and 12. Imagine Greenhaven is a registered nonprofit corporation with the Secretary of State's office for the state of Georgia. And Imagine Greenhaven, the respondent, was served by mail at their registered agent at the time. Respondent Greenhaven did not file a response. In Ms. Leak's complaint, she alleged that the respondent violated the Campaign Act by expending funds to influence legislation for the creation of a proposed city, which would have been Greenhaven and unincorporated DeKalb County, and that the respondent failed to register with the commission, that the respondent failed to identify connected organizations, coordination with the legislative agenda, and a failure to report financial activity. Ms. Leak also noted and included as an allegation that there was a use of a lobbyist who was compensated in excess of $10,000. And the crux of why this was recommended for dismissal is because there was no ballot question that was presented to voters. And so without a ballot question, there could be no committee that would be required to register with the commission, whose expenditures the commission would then have oversight for. There was also no evidence of a political action committee, and without that, there are no connected organizations. And finally, Imagine Greenhaven, of course, could not be required to register as a lobbyist because Imagine Greenhaven, although a person under the statutes of this state, is not a natural person, which is required for a lobbyist. And while Imagine Greenhaven may have paid a lobbyist to speak on their behalf, that lobbyist would be required to report, but Imagine Greenhaven would not. And so for those reasons, these two matters were recommended for dismissal.
That's good. That's good breakdown too. That took a lot of analysis on that one. And so is that all of them? Is matter of concern the next one as well? Or you got
Right, so that's for 2000, that's for 002 and 004. They're listed as two different names, but, and I have the documentation if commissioners would like to see it. It's one entity. It was originally Concerned Citizens for Cityhood of South DeKalb, and then a name change was filed with the Secretary of State's office, which changed it to Imagine Greenhaven.
Okay.
But Ms. Leak is on the phone and sent an email earlier asking to be heard.
Okay, well, we should hear her.
Me?
Are you waiting for me?
Yes.
Okay, good afternoon. My name is Claudette Lee, and I'm a 50-year resident of DeKalb County, Georgia. I started out by trying to get some open records requests. We filed initially, or what I filed initially were, again, there were 4 different names. The calculation names and ultimately ended up with Imagine Greenhaven. But the case numbers that I have, I'd like to clarify something. One of those organizations was the South DeKalb Improvement Association, Concerned Citizens for Cityhood for South DeKalb. That was the CCCSD. Greenhaven Business Alliance, that was initially rejected with the initial filing. And then South DeKalb Improvement Association was also dismissed. Greenhaven and Concerned Citizens for Cityhood and South DeKalb are one and the same. All they did in May of 18 was to change their name, but it's the same organization. And one of the reasons that you're always going to have differences of opinion about any piece of legislation or lobbying to get legislation done. And the primary thing that I was relying on was exactly OCGA 21-5 through 12 and 21-530. In looking at that legislation, these groups or organizations, number one, they failed to complete a form, the Commission's RO form. And number two, the report, they were not reporting financial contributions. These organizations have been in effect trying to get a city created in DeKalb County since 2014. The other thing that they did is identify that we identify that they are a connected organization because they all serve the same purpose and they were cross-pollinating the offices. If you went to the Secretary of State incorporation, you saw that the chair of one of these groups was the CEO of one of the other groups. So there was cross-pollination. We did try to do an open records request to just see, because the community was asking, where is their money coming from? They paid UGA over $20,000 for a feasibility study. Looking at the Secretary of State website with the registered lobbyists, all the form allows you to check is, does this lobbyist get paid by clients more than $2,000 in check? Yes. Yet nobody knows who is behind these organizations. And to say that they are not lobbying and their executives are not lobbying is incorrect. They go down to the General Assembly and individually lobby legislators in addition to the work that's being done by their paid lobbyists. These are their leadership members who are doing that. I'm doing as a citizen of DeKalb County. This has turned into a David and Goliath situation. They have funds that they have donation boxes all over your website. I provided documentation to support that. The rest of the organizations, there are different ones throughout DeKalb who are against the cityhood initiative, don't have the money or the funds to pay for lobbyists. We're not jealous. We just want to know who they are and whose interests they're really serving by identifying who these folks are that are being paid to lobby the General Assembly. Now, I heard that because it wasn't a ballot initiative, this law would not necessarily apply, thus the reason for an administrative dismissal decision. But I contend that when you go down to the state legislature as representing an organization, you are in fact a lobbyist. So they got one that's paid, and then the others down there who are officers of these organizations are independently lobbying one-on-one, sometimes in public places, and they do it at public meetings. So to say that they're not trying to influence a ballot initiative, it hasn't come to a ballot yet. The community, those in opposition, have been very successful in blunting their lobbying efforts. But they have money that's coming in, and as I understand it, whether they're lobbying or not, they're supposed to fill out that RO form, which when I contacted the Office for the Finance Commission, I was told that they had not stopped. There were no records. It started out as an open records request, is what I asked for. And I wanted to see if they had submitted an RO form indicating that they would be collecting money. There was no record on file with the Transparency of Finance campaign office. So from that reason, I provided a great deal of documentation to support that they are connected organizations. And I guess the only question left for me is, what is the recourse if this administrative dismissal is approved?
Ms. Browder?
Well, I don't think that I could offer clarity on the request for recourse. I might be able to shed some light on why things haven't gone the way Ms. Week might have thought they would have gone. I would first say that I would just, as a citizen, empathize with you and your concerns about the place where you live and have called home for an extended period of time. But I would also add that the absence of a ballot question, is the reason why the organization, which is a registered entity with the Secretary of State, does not fall at this time under the purview of the Commission's authority. And that also relates to connected organizations, because without the ballot question, there is no political action committee, which is required to have connected organizations. And just as far as nonprofits and how they receive funds and how they expend funds, the commission does not have authority under the Campaign Finance Act as it relates to IRS 990s. And so that also would be outside of the purview of the commission. And for those reasons, that's why we recommend dismissal.
I'm sorry, I apologize.
Oh, no, it's okay.
It's not what constitutes a political action committee.
Sure.
Yeah, and then let me respond to that. Ms. Lee, first, we appreciate you showing civic engagement and appearing before us and raising all the concerns you did. And all those concerns are equally important to us. And so I just want to emphasize on behalf of the commission that we really do appreciate that engagement. And I think you've articulated a number of concerns, and a lot of it is it's about just legal requirements. And I'll just break it down in just two simple sentences. First, to be a lobbyist, to be required to register as a lobbyist, you have to be a natural person. So because these are entities, they're not natural persons. Now, any of the individuals, if they're out there lobbying and they're natural persons, they would have to register. The second point, which Ms. Braddock just made, is that in order to have to register for an independent committee, they're going to have to be influencing an election of some sort. It doesn't sound like there's any election on the ballot. And so because of that, it doesn't apply. Now, if you found individuals who are furthering this cause and they did not register as a lobbyist, and again, I'm not speaking on behalf of the commission, but that could be something where you could raise in a complaint. And so I hope that provides a little bit more clarity.
It does, and I appreciate your bringing clarity to that, because I understand the line is, but these folks are individually in their capacity as officers of these organizations going down to the General Assembly, meeting one-on-one with representatives in the House and the Senate, and lobbying their cause. And to the point, I'll just throw this out here for FYI, they even put, because they didn't like the fact that some of the legislators from the CAB had not signed on to this particular initiative, they sponsored their leadership to run in opposition to them 2 years ago. Okay. So I just point that out, and I will come back if that's an option of giving you the fact that these individuals have not registered, and to just show that I tried to do due diligence before making this complaint. Mm-hmm. I started with your commission and agency and requesting an open record request of any kind of reporting of finances and all. Then I was sent to the Office of the DeKalb County Voter Registration and Elections and did the same thing and requested an open record, and they had no record of any of these folks. This is not an opinion. I have spent the last 3 years down in the legislature myself, so this is what I see firsthand. I've been in meetings where they have grounded the individual leadership, they grounded the legislature.
Well, Ms. Lee, we've got I don't want to interrupt you. We've got a little bit more on our agenda, and I don't want us to get too off topic on just this issue. But what we invite you to do is, if you identify any individual who is engaging in activity which qualifies under the Act as lobbying, and you identify that individual, we invite you to file a complaint. And we appreciate your interest, and we appreciate you attending telephonically today. And if you feel comfortable, hopefully when COVID gets better, we invite you to attend any of our meetings in person. So thank you again for
The
that.
opportunity.
All right, thank you.
Thank you.
Is that all, Ms. Browder?
That's all.
Very good. Okay, so we have completed section 7, and we will move on to section 8 in the agenda, which is the report of the executive secretary.
Thank you, Mr. Chairman. Gonna address a couple issues that I think are important, a couple issues that may have been more important before COVID happened. But I'll take those in order. Obviously, the big one is the COVID-19 pandemic and the response and the fallout from that. So just to keep the commission aware of how we have dealt with this and sort of evolved, basic timeline that everyone knows, March 2nd were the first 2 positive or presumptive positive tests in Georgia for COVID-19. March 13th, after, I guess, rumors of suspended session, some things happening, we tried to be proactive before we had any orders that allowed us to do that, and we went partial telework. And we have rotating teams with about half the office working from home, half the office in, rotating daily. Once some orders came through, about 5 days later, we transitioned to full remote work from home. We extended that, or I guess I extended that at various points through May 18th when the physical office reopened. And even then, that was on a partial rotating basis again with the elderly and medically fragile restrictions and considerations in place. We have since returning upon executive orders and guidance from both the city of Atlanta and the state of Georgia, increased through our partnership with the Georgia Building and Civic Authority, daily sanitation of the office entrances. We've purchased additional hand sanitizers throughout the office. We have actually affixed a plexiglass, well, yeah, the masks. I don't know that I can take credit for that, Mr. Chairman. That was all you. But for our receptionist, we have affixed a plexiglass window with a little slide to prevent germs from coming through that open air entrance. And to this date, no employee has tested positive for COVID-19 within the agency. So remote working, obviously not ideal. And I think in some areas of government and business, we've gotten more efficient. And I think there are some areas that are not necessarily attuned to that. But from the outset, to ensure that staff maintained diligence and we were accomplishing things, we implemented a structure where initially we had daily meetings with senior level staff, and each manager of a different area of the office would report what the people working under them were doing. And we were keeping logs to make sure we were holding people accountable and getting as much done as humanly possible while working remotely. Eventually that sort of transitioned to a meeting every few days, then a meeting once a week, and we've gotten pretty efficient at making sure we're collecting reports or whether it be formal or informal, that we're all on the same page and we're aware of what we're doing. An example of that is lobbying. We have in the state of Georgia currently 1,036 registered lobbyists. 109 of those have been additional and have been added as new lobbyists since the COVID-19 pandemic started. And we've gotten a little more flexible in terms of what we can do electronically with lobbying registration now, and I think that's an area where we've improved. But in any event, we are still able to do things remote that maybe we weren't before. So I think all in all, commission staff has done a good job adapting as best as we could. I think, and I stress this, with our employees throughout this, that we will be held accountable throughout the end of the year to show that we've been working cases and that we've been addressing lobbying issues and that we've been doing, all the things we need to be doing. And I feel confident that we're going to be able to do that. The e-filing system update. Obviously, this is something, I don't think, Commissioner, to turn my back on you, but this is something that I've been talking about since I took over. The e-filing system we operate on currently is somewhere between 15 and 17 years old. I mean, Commissioner Thompson knows the exact number. I'm open to that, but it's.
I gotta age myself.
And when you talk about technology, and not to beat a dead horse, we're talking about iPod technology operating in an iPhone 11 world. So we are, and I've said this from the beginning, we're in dire need of a replacement system. Over the last year, we've worked diligently with the Office of Planning and Budget, with the State Accounting Office. We've procured bond set-asides to pay for this. Because of COVID, we're about, ideally, we would have entered into a contract by now. We're a little behind, and so I can't be too specific given NDAs, but I can say that we are moving forward. We are close to making progress there. Again, with still the same objective and goal of trying to implement a new system before the next election cycle. So there's good news there. Hopefully at our next meeting I can update a little more specifically. But I'm pleased that in the last year within the structure of state government, we've been able to clear a number of hurdles to make this hopefully a reality here pretty soon. The 2020 COBOL National Conference was originally scheduled to be hosted by Atlanta. So we were going to be the host site for the National Ethics Conference, or International, I guess I should say. To that end, we are a member of the host committee, which involved helping plan the conference, plan the sessions, plan the lessons and the speakers and the panels. I was involved with other people around the country in different states who were on that panel and know how to do that a lot better than I do. But was able to help out a little bit, and we had made some progress, and then of course COVID happens, and recently they have canceled the in-person conference, which was scheduled for late December, I believe. So that has now gone to sort of a scaled down, interactive, online version of the conference. We're still involved with that on the host committee, although we have a lot fewer duties and responsibilities, and particularly as the host committee, I think this commission as a whole was going to be more involved in the presentation, the implementation of those classes. But we're still moving forward with that national conference to the extent that we're involved. Finally, and this is, Mr. Lane and I have talked about this. This is an issue to make everyone aware of. I don't have a perfect answer short of legislation, which we're working with the legislature on. But we were made aware at some point, let me back up a second. Elected officials obviously file personal financial disclosure reports every year. And the timing differs whether it's an election year or non-election year. But they file personal financial disclosures. The level of office dictates how complex and how in-depth that disclosure is. Public officers, so people appointed to, say, the gaming board, file an affidavit of public officer that says, I have taken no action in my role on this board to personally benefit myself. You fine gentlemen are fortunate that you are the one commission and board that get to do both. So you have some understanding of what I'm talking about. The point behind, and the law is clear, that the intent behind the affidavit is to ensure that no members of a commission, board, authority are making policy decisions in that role to benefit themselves financially. And that's a good thing. There is, however, a sort of unforeseen consequence when you talk about the judiciary. If you are elected as Superior Court judge, you are immediately considered a member of the Superior Court Judges Council. Even though 95% of those judges don't actually vote on any policy, don't go to any meetings, might not even know they're on the council. So there has been some inconsistent messaging in the past about whether judges had to file that affidavit or not. I was approached at some point a while back with sort of the dilemma of, we've been told for a few years now that we just have to file the PFDS. And I informed them, well, look, the intent is not to, you were advised incorrectly, but I am telling you moving forward, there's really not a whole lot we can do. You're going to have to file both until we can make a legislative change to fix this issue, or even create some sort of legislative language that says if you serve on the judges council but don't vote on policy type issues, the PFDS can sit in the place of the affidavit. There's not a perfect answer. We're working on that. I'm working very closely with Cynthia Clanton, who's the director of the Administrative Office of Courts. After this issue arose, we got together and talked about it. Shortly thereafter, the Chief Justice and the Presiding Justice invited me to their next quarterly meeting to talk about this issue so that everyone's on the same page. And I think we're in a good place where everyone's communicating. But this is definitely an issue that particularly impacted the judiciary because they weren't really aware, and for some logical reason, that it applied to many of them. So that's something that we actually have spent a fair amount of time thinking about and toying with how to make this a little more common sense moving forward. And I just wanted to put that on everyone's radar.
Okay, good. All right, and Mr. Fuller. Whenever you're ready, we're ready. What mic are you?
I think I'm supposed to be 10, like 10.
Sitting in front of, can you hear me? There we go. Thank you, Mr. Chair. Just a couple of updates on pending litigation that we have. An oldie, but still a goodie, the School Reform 2016 case involving Frank Myers and John Thomas formed this group of people. I'm leery in calling it an independent committee or PAC because it's not clear which. But I have filed a statement of matters asserted with the Office of Administrative Courts. I filed that back in March. And for the record, that's case 2016-00-0046. We are currently awaiting a hearing date. Reason being that it's taking this long is when I try these cases, venue lies in the county in which the offense was committed. So OSA has to coordinate with Muskogee County courts to figure out when we can have access to a courtroom to try the case down there. So I think there's just still some back and forth going on between OSA and Muskogee County Courthouse, but that's in the pipeline. Also another case in the matter of Sabrina McKenzie, it's 2018-0058, and then 2018-0109. That also has a statement of matters asserted filed with OSA. Currently, the hearing date is set for July 14th. So that will be here in Atlanta. The hearings are open to everyone, so if anyone wants to come and attend, you're more than welcome to come see these in action. So I invite that to you guys as well. I do think there's a possibility that case may settle prior to July 14th, but in negotiations with opposing counsel, there's, dare I say, an element of gamesmanship of not disclosing proper information. So we're just going to be working towards that July 14th hearing date and then go from there. Also, there is a case that was filed, or a motion to quash that was filed by New Georgia Project and New Georgia Project Action Fund out in Gwinnett County. I can't remember the complaint number, but it's in reference to a complaint that the commission filed against them back in December that was heard. And I believe there was arguments about subpoenas and motions to quash that may have been, that were denied at that time. But since then, I don't know if you allow me to speak to, Joe, I guess the new subpoena that was sent out.
Yeah.
I'll just touch briefly on it, but
They didn't get the bank record, so we speak to
Yeah.
the bank directly.
right. So at the hearing here, there was a subpoena that was sent directly to the entity that this commission denied their motions to quash. I believe they're still, they weren't complying with that subpoena to turn over requested documents. So in lieu of that, there was a second subpoena sent directly to the bank. The banking laws in this state allow for account holders to file motions to quash, or the third party motion to quash. Since the subpoena is directed to the bank, but the account holder can file a motion to quash, and they do that in Superior Court, again in the county in which the bank is located. So
They filed their initial motion to quash back in March. I believe March, we were served on March 31st. I've since filed a response and they have filed a reply. We're currently awaiting a hearing date. I believe we've cycled through, we have 2 judges at this point. It's been consolidated, and then the first judge who was consolidated in front of recused, and then the second judge was recused. So I guess it's a little bit of hot potato going on in Gwinnett County right now before we get a hearing date scheduled. Also, just a brief update on the commission versus New Georgia Project et al. I believe I might have spoken briefly about this at our last meeting, but the last update I given to the commission, and this was based on a hearing that we had in Fulton County Superior Court back in February of this year, where our office on behalf of the commission filed a motion to compel a subpoena that was denied on jurisdictional grounds. At the time, we filed an application for a discretionary appeal. The application had not been considered at the time I had given the update to the commission. Since it has been considered and granted, and through, I guess, the judicial, we have until the end of this month to file everything, which we're on target to do. I'll probably do that actually tomorrow. And by filing our appellant's brief as well as the request for oral argument. So those will be done. And then lastly, I've got another matter in the matter. That's another old case out of Muskogee County. I've been actively working on trying to get a consent order for Ms. Harris. We did have a statement of matters asserted ready to file to bring that case to a hearing, but Ms. Harris insisted upon us trying to work things out. So I was hoping to have a consent order here to present to you today. One has been sent to her multiple times, and I'm just waiting for her to sign that and get that back. So hopefully I'll have that to you guys by our next meeting in August. So
good. Well, thank you, Mr. Fuller, and we appreciate all your hard work, and we appreciate the commission staff's hard work. I know it's been a lot going on, and we do appreciate that. All right, so public comment. Do we have anybody here for public comments? Okay, I don't see anyone. Well, next we will enter our executive session for personnel and budget reasons, and I will make a motion to enter that executive session if I can get a second. All right, we have a motion, a second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Good. So how would you guys propose we do it? Should we stay here and then other people?
Yeah.
Okay.
Oh,
I did.
You can always do it after your session.
But they haven't said something orderly in executive session.
No, don't worry about it.
Yeah, we can come back and do it after.
What, you want to do that? You think it's easier? All right, let's do that. I'm going to get it.
What?
Okay, and what is that? I'll fill out the paper. Yes, please.
Well,
let's just,
Let's go back in.
Yeah, okay.
And then, yeah, let's go back.
Okay.
Sorry about it. We don't want to leave you here later than we have to, so and I don't think it'll take super long. All right, I'll make a motion to end executive session and re-enter our open meeting if I can get a second. Second. All right, we got motion, a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, we will jump to, and Commissioner Thompson correctly pointed out, and you know what, and that also reminded me of one other thing. And Christian, you're going to hate me for this. Advisory opinion, requested a year ago. How are we looking? We got to have it about to come down the pipe.
I have no updates on that, unfortunately.
I'll try to follow up. We really need to get that. Yeah. I know it's not on you, but
So one day when I'm boss, maybe I can make things move faster.
well, try to do me a favor for August. Will you get us a report? And if it helps, say the commission requested whoever's job it is to draft it, become report on it.
No, I mean, it's draft.
I mean, I just would.
Signed.
We need to get that.
No,
I know.
I've been proactive, and it's a very sore point to talk about.
Yes,
Mine
okay.
was on it too, so.
I know, we'll do what you can.
I will.
All right, and next we'll go to, section 10, rule discussion, and who on behalf of the commission will be presenting? Mr. Lane, okay.
Okay, I promise not to belabor these points too much, but since we do have an active commission, and sometimes members of the commission have very divergent viewpoints from one another, we're coming across some rule drafting that we need to accomplish, and we thought it would be wise to ask you on the front end what your general policy thoughts would be on certain matters so that we can begin our rule drafting and then bring to you for public comment and your consideration rules that are tailored, that will give you a much better rule and a better framework for you to discuss ultimately what that rule should look like. That way we're not just coming out of left field and surprising you gentlemen. Now, the first rule that we implementation of Advisory Opinion 2020-01. As I'm sure you'll remember, back in April, we had very long discussions about the ability of candidates who are members of the General Assembly to spend their own campaign funds, and how are they reported? Is it prohibited by the Act? Now, our Act is drafted very broadly, and the way our Act currently states is that no member of the General Assembly, while the legislature is in session, shall accept a contribution. Our Act goes on to define a contribution as including a loan, and it's drafted so broadly that it could encompass a candidate using their own campaign cash. The problem we run into is our statute conflicts directly with federal precedent and the First Amendment, in which you cannot bar members of the General Assembly from spending their own money because it's too broad of a restriction, it's unconstitutional to apply, and I won't bore you with it. But what the commission found was that, and advised was that members of the General Assembly can spend their own funds, and the proposed AO had a kind of a implementation advice. If you go ahead and loan your campaign funds or you spend your own personal money and then you reimburse yourself, you have to reimburse within 60 days or that expense is treated as a loan to your campaign. The commission, after discussion, removed that section of the advisory opinion, so we have a bit of a gap. So now you have members of the regulated community that know that they can spend their own funds, but they do not know how they are supposed to report those during a session. Is it a loan? Is it a campaign contribution? Is it a reimbursement for a campaign expense? What do they need to do? And that is the question we're bringing to you to kind of pick your brains and poll you. Should they have 30 days, 60 days, 90 days? Should they report it as a loan? Should they report it as just a reimbursement? What say you? That's kind of the first rule discussion we're trying to open the floor and see what you think.
Who wants to go first? Commissioner Lawrence?
Mine's purely historical because I can't remember. Remind me why we took out the 60 days.
There was not support for it.
It was your idea.
It was not mine. I had a number of other ideas about that advisory thing, if we want to revisit it. But I don't think that I have the best. So.
Correct me if I'm wrong.
Correct me if I'm wrong, Commissioner Thompson. But the issue was we were imposing an arbitrary deadline that was not supported by anything in existing law. So the sentiment was, let's pass the rule that allows it, and we'll come back on the back end and create a framework by rule by which they have to reimburse it through or by, so that it's not just an indefinite loan. That was my recollection.
Commissioner Thompson?
Why wouldn't we just have them reported as a debt incurred until such time as it's reimbursed? Or a deferred expense? They both do the same thing. There's no contribution limits, and if they're doing it themselves, you know, it has nothing to do with the contribution if it's a deferred expense.
That is correct. And that had been standing commission advice until the advisory committee. We've always maintained, even the way the code is written, that if you spend your own campaign funds, you could loan your campaign as much of your own money as you wanted to. The only limitation you had on its repayment was that after the election you were capped at $250,000 as your loan repayment. So my understanding is that there was concern that that was contrary to the spirit of the law, and hence we got the advisory opinion request.
So we're being asked to give a deadline by which the candidates have to repay back the loan?
Because what we're saying right now is, if they are expending their own money during session, they don't have to treat what they are spending as a loan to their campaign. They are simply making an expenditure out of their own personal funds, and then if they quickly reimburse within a time period certain, then it is just a reimbursement of a campaign expense. It would be an example of, outside of a general assembly session, you're running for governor, you break out your credit card to pay for a dinner.
No, I got that, but my question is, so that we are saying you have to pay back the reimbursements.
Correct.
So many days, so it's not a loan, it's just you gotta repay it. And so the question before the commission is, how long do they have to pay back?
Yes, sir.
The reimbursements, okay.
And, Mr. Chairman?
I think this issue is within the context of the AO and the AO's language, which specifically addressed during suspended session or during session. So I don't know that there's gonna be support for this, but it can be from a time, a finite time post-session ending. I mean, that's an option, but I just want to keep it narrow to, this is related to session only.
In that, wasn't that part of the discussion with the legislators that they wanted a certain amount of time after session, I'm assuming, so they could raise money to then reimburse themselves, right?
Correct.
They wanted a numerical deadline.
Yeah.
Right, but after session, yeah. Which makes sense. I mean, I can understand why.
So we just need to pick a date,
A date or a number of days?
a number of days. It can't be indefinite. I mean, otherwise you never have an obligation to do it. I mean, so it has to be, and it's only implicated in suspended session.
I'm trying to remember the language of the AO.
I mean, that greatly limits its application anyway.
Especially when you have a question about what's suspended session.
If they show it as a debt incurred, it will constantly and repeatedly be considered an indebtedness. And a debt incurred or a deferred expense is not a contribution necessarily. So they're still reporting it, okay? They're still carrying that debt. They can't stop reporting with the commission until such time something happens with that debt, okay? So I don't know why we're complicating this, that we're saying we have to pick days.
Well, then we change it though.
The reason it was complicated is that there were members of the commission who felt that the contribution ban, when you look at the definition of contribution, includes loans. So that would include, it doesn't specify loans from third parties, loans from banks, it just says loans within the definition of contribution. And when you look at the prohibition, it says, no member of the General Assembly shall accept a contribution.
Yeah.
So it's very broad. And what we were trying to do was thread the needle so we don't have an invalid application of our statute because it encompasses that loan. We're trying to find a way that they can make their personal expenditures without taking out a loan.
Mm-hmm.
Because we're looking at a loan as a longer term vehicle for the financing of debt, whereas we were trying to treat the personal expenditure as like a revolving charge account. You put money on your American Express, they're going to give you 45 days to pay it back without it being considered a loan with interest. It's like a charge card. That's what we were trying to accomplish with the AO. Now, if y'all want to say with the rule that you can do a loan during session, I'm all for it.
No. Well, because the rule was you can't loan yourself money during session.
Correct.
You can't raise during session. There was uncertainty whether session was going on.
Correct.
Therefore, there is no way for any incumbent to really spend money unless they already had a significant amount of money in their account.
Correct.
The way you thread the needle is you say you can incur personal expenses, which you thereby reimburse yourself, but you have to reimburse yourself for a certain amount of time. Seems like a pretty good idea. We just got to pick the amount of time.
Correct, because in the advisory opinion the commission adopted, you stated that the personal expenditures were not a transfer from the person to the campaign.
Yeah. So we just got to pick the time.
Uh-huh.
Is 45 days enough?
Still back on the confusion train here.
Okay. Rick, you can't loan yourself. So
We're not loaning stuff, you're still reporting as a debt incurred.
Robert, what do you say to that?
It's a debt incurred.
I mean, it's, the debt incurs the loan, because
Yeah,
you have
that's
to
what I'm
reporting the debt.
No.
So a deferred expenditure is, in an accounting world, a deferred expenditure is, I go to my sign maker, he gives me the signs, he hasn't given me the invoice. The invoice is coming. That's like a deferred expense. I haven't yet expended the capital expenditure, if that makes sense. Probably doesn't, but, you know, it's, I get what Commissioner Thompson's trying to accomplish. We just don't have the mechanism within the report to get it done.
I disagree. I said we do, but.
What's the, I guess Commissioner Thompson, what's the, I mean, you think we're adding complication because we're putting a date by which it has to be repaid?
Yes, because.
And, well, I'm sorry, real quick, the corollary is, because I mean, my concern is kind of the same, like, when are you ever gonna know something did happen with it? And you're saying when it changes from a debt to something else in your reporting, is that right?
The report, when you file the report, and if you paid for something for your campaign, you could show it's a debt incurred. The e-filing system allows you to do that. That then takes it, does not put it under the loans, it puts it underneath the indebtedness as a debt incurred, okay? So now we have traction of what the debt was, because on the expenditure page, there is a system, when you put it down there, I paid for signs at Pete's, then we know Pete is owed money, and that's how it gets onto the indebtedness page. So now we know.
But who's incurring the debt?
The campaign.
That's the point, the campaign, the whole point was the campaigns had no money. So in this situation, if the campaign's at $10, and let's just, you pick your XYZ incumbent is running, and he's like, I have $10 in my account, I'm running, I can't loan any money, I can't raise any money, how am I gonna spend any money? Well, what this does is you say you spend personal money, which you then, the campaign after session, when you can raise money again, will pay you back, which they have to pay you back within a certain period of time.
In a system as we have it now, correct me if I'm wrong, is not going to be able to show that. So we're going to say here is the point that we're going to pick a number of days that you don't have to disclose it.
No, so it will be disclosed as a reimbursement to XYZ legislators once they make the reimbursement.
So they're going to be able to pay all this stuff, whatever they want to do. If this session, like we had the April 30th. So if they did stuff on April 29th, then nobody's going to know they did it on April 29th before the election actually happened, right? So there's no transparency there.
Until afterwards, that's right.
And then we're going to say, we're going to make up
I
some
mean,
number.
a number of legislators have already done
I'm based on our AO probably.
it. Yeah.
Well, if it helps the reporting schedule, in that situation, they wouldn't be reporting anything until June 30th.
That's not true, because we have April 30th. We're talking right now, so we're talking about the next 9 days, okay?
The alternative was if an incumbent didn't have, I mean, we're going back. If an incumbent didn't have sufficient funds in their campaign during the extended session, they were put at a significant disadvantage. And so that ship is sailed. I mean, that decision's been made. We now got to work within the decision that's been made. It's just about when do you have to report those reimbursements and commence the reimbursements. That's what we've got to decide.
Mr. Chair, if I may just offer a thought.
I think when we're talking about, I guess maybe the financial instrument of a loan, I'm thinking back to some of the discussions that were had surrounding the Oxendine case, and I can't help but think that part of the critique there when we were describing what an actual loan was or is necessarily encompasses, promissory notes, repayment schedule, all these sort of anecdotal bits of evidence that make that financial instrument actually a loan. And so I'm wondering, to Commissioner Thompson's point of debt incurred, are we treating the personal expense or the personal use of money and then the campaign reimbursing that as necessarily the same financial instrument as a traditional loan? And
And not necessarily to make things a little bit more complicated here, but I'm concerned on the far back end of, if we sort of redefine what loan means in this context, how it might be used later on down, thinking like in the Oxendine case, how he described, he called it a loan because this is what he did, right? There were no, it's alleged that there are no financial instruments that are actually involved that make it constitute a loan. So, i.e. interest rates, repayment rates, repayment schedule between the person taking the loan and the bank. So
Now,
I just offer that as a thought to.
Well, just to keep the ball rolling, let's do this. Confirm it only applies, let's just do 45 days at first. The commission's now making a decision, we can amend it, we can adjust it. See if it's we need to see the language. If it's limited to a suspended session, it's only going to be implicated in these unique situations. I mean, remember, we were presented with just a situation that the law didn't contemplate for. I mean, so it's not going to come up every year. So just add that. Let's let the commissioners look at it. We don't have to adopt it in August. We can, but at least that puts something in paper. We can think about it. And then the next meeting is when? September? If we need to wiggle with it some between August and September, we can do that. And that keeps it moving. Because it's all of us are smart people. And the thing is, it's such a screwed up situation. It's hard for smart people to deal with a screwed up situation, which is what it was. But we're really just trying to provide clarity in that very limited situation, which I hope if we get hit with a global pandemic next year, we might just be folding it up, but do that, and then we'll take a look at it. Okay, next rule.
Thankfully, the next rule is quite easier. Since we are in these rather different times and we have to do telephonic hearings, the Uniform Superior Court rules provide the ability, as Uniform Superior Court Rule 9.1, for courts to require litigants to appear via phone. And the Supreme Court is looking to expand that rule on a temporary basis during COVID-19 to allow for telephonic hearings for a greater range of cases. So we've provided to you both Uniform Superior Court Rule 9.1 and the enhanced one the Supreme Court is considering. And surprisingly, because I'm sure you'll know, we don't have an internal commission rule, nor does the APA anticipate us using any kind of telephonic hearings for our preliminary hearing procedures. So we're asking the commission if you'd like for us to adopt a consolidated rule that would govern our preliminary hearings that would allow us to require persons to attend remotely. Because right now, if they can't attend in person, they can look at us and say, I'm not coming, and there's not really much we can do about that, aside from subpoenaing them and forcing them to come that way. So I'm just curious if you're interested in it, if you'd like a rule to address those issues and how we govern the telephonic hearing.
Well, in light of COVID, yes.
Right. To the extent, do y'all want it to be more like the current drafting of 9.1, which is basically it's by telephone and it's for a limited types of cases, or are you looking for a more expanded Supreme Court version where it is pretty much for every type of case that could come before us, and it's by Zoom? And
what do the commissioners think? I think we should get a draft. I mean, the thing is, if you're someone with an autoimmune disease or you don't feel comfortable coming because of COVID, I don't think those people should be prejudiced like Ms. Little. I don't think Ms. Little was prejudiced, but I wanted to make sure that she didn't feel like she was. So yeah, I think we should absolutely put a policy together.
And then that's it. Well, then, to that end, Mr. Chairman, I would suggest the bigger version, more inclusive, so that we don't come back and, we can only do certain things, and then we really need to have a full hearing and we didn't address the rule to deal with that framework. That would just be my suggestion.
Commissioner Watts?
Yeah, I just haven't studied this Supreme Court rule enough, but is your suggestion if we do the more fulsome rule that any and all activity before the commission, with caveats or whatever, can take place via remote technology?
I think, Mr. Lane, correct me if I'm wrong, I believe the Supreme Court's 9.1 excludes criminal, it's limited to civil. But I do believe it includes everything up to a civil jury trial by right, and even then if you waive it. So for us having a full preliminary hearing, yeah, we could, I believe a rule could be constructed to do that.
Yeah.
And it would allow you to do the final hearing after OSA has issued its determination, which is where you impose final, your final order of punishment. So.
Well, let's just put a draft together. I mean, I always prefer people to come in person. I mean, but these are unique circumstances, and I think we need to have contemplated for that.
Would the commission like for a bifurcated where you have the current version of Uniform Superior Court rule for normal times, and when you don't have a judicial emergency in place, and then you have a more expansive rule that is triggered whenever the Supreme Court declares a judicial emergency?
Not really.
Okay. See, I'm glad I asked to save me work.
I don't want to overcomplicate it, but I do think we should get something. And then we can consider that in August too. Good. All right, anything else?
Just one quick point, Mr. Chairman, backing up to the previous rule. The AO did specifically address while session is in suspension.
Okay.
So it is narrowly tailored at least.
Good. That's helpful. All right, anything else before we enter executive session? Commissioner Thompson, triple check me now. All right, I'll make the motion that we enter executive session for budget and personnel reasons, if I can get a second. Okay. Motion and second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0.
I'm ready to stop screaming. Sure, we're offline before.
Yeah, just do